see it before. Hey guys, I'm here with Bruce. Patrick is going to be a little bit late, but he's going to be popping in with us in a second. I've been slacking off on the David Gingras proceedings. The Laura Owens attorney, David Gingras, is in the middle of a case with the State Bar of Arizona, where lots of charges have been brought against him, and he is totally handling it with grace and poise, and
very
not
good,
crashing out on the internet. So I haven't read, or I have read some of his blogs since I last talked about this. I think you and I talking about this was the last time I did a stream on it. So it's been a couple weeks.
Yeah.
But
sure.
I'm not watching that man's videos. I'm just not. I'm sorry. But it was brought to my attention that he, in one of his videos, had some stuff to say about Megan, our friend Megan Fox, because he was upset about what Megan said when she was reading the documents related to this proceeding. So I wanted to start with that, which will probably work out because Patrick's going to walk us through some of the legal stuff, but we can go ahead and get started on that. I have this video here from Megan that we will watch that she posted to X. So let me pull it up real quick. And we've been, chatting about this back and forth a little bit. I just haven't done any videos on it or anything in a while, because I was like, I'd rather talk about like legit anything else for a minute there. But it says David Gingras is threatening to sue me over this clip. He says he's going to teach me to watch my mouth. This is a free speech attorney, folks, sharing again because nobody tells me to shut up. Well, of course, that's the response he's going to keep getting from people, because it's like, why would you threaten to sue someone when you know you're not going to win a lawsuit over that? Like, there's no way. Especially like for a self-described free speech attorney. But we'll watch this clip real quick.
Also, telling someone to watch their mouth is rude.
Yeah, it is. Of course. All he has to do is not watch. Literally all he has to do is not watch.
Or
like, we let him talk his shit about us, and we don't threaten to sue him. You know what I mean? Like, it's a crybaby behavior, honestly. It's pathetic.
He could watch and not be rude.
Yeah. I don't think that's possible.
Oh.
All right.
He can work on it. He can work on it.
Here's how David Gingras could have done this as an attorney who was responsible and ethical. You come into a case like this, you see the record. The record reflects that there's all this back and forth, he said, she said, about whether or not this chick is pregnant. This is very simple. You say to your client, sign this HIPAA form. I need your medical records from the doctor. And if you won't give me that, I'm out of here. And if she did give him that, and then he goes to the OBGYN and finds out, not only is she not pregnant, but she's never even been to any of the appointments that she set, it's done. It's over. There's no case here. And you leave. Like, you don't take the case. He had a duty to do that. He had a duty to find out if she was pregnant or not. It's that simple. It's absolutely ridiculous what he has done in this case. It's ridiculous. And the bar is correct in holding him to account for it. Respondent had a duty to diligently investigate and research everything that Owens told him or provided to him. So if she hands you a sonogram with her name on it, you say, I'm sorry, Laura, but that's not good enough. What doctor did you get this from? And I need a release so I can get it from the doctor. It's that simple. Placed responded on notice that Echard had claimed that Owens was not pregnant, which created a duty on his part to ensure that his investigation and research thoroughly addressed everything that Owens told him or provided to him. You remember, every time we would call him out on something he didn't know or was just pretending he didn't know, he would say, well, that was before my time. There is no such thing as before my time when you're an attorney with a case. You're supposed to research the case before your time. All of it.
Right.
It seems like Megan is just either reading from the bar filing or she's expressing an opinion.
That was, yes, her opinion in response to the bar's filing.
Or a memory about the times he said that was before my time.
Honestly, all of the above.
And I don't see anything in there that's a problem, because if he claims that she's making a clip here and lying about something, there's two parts to it. Right? You have to show that she said something that was wrong and prove that it's wrong. Like, she made a false statement. And then part one's the easy part, because people make mistakes all the time, right? But part 2 is hard. You have to prove that she had intent to deceive you, and that's a lie. To disambiguate it from a mistake or an opinion or speculation or something like that. Proving a lie is actually kind of complicated because you have to have proof that someone was trying to deceive whoever they're talking to.
Right. Lots of people who you would think on the face of like on the face of what a lot of people say, you would think they would have a great case for defamation, but it's very, very difficult, like you just said, to prove. That's the thing is like a lie, and B, you knew it was a lie and had malicious intent in putting that forward.
Yeah, you could just be wrong. Like, I could say, hey, I thought Lauren had $5 in her wallet, and there is no $5. Am I a big liar? No, maybe I'm just mistaken. Maybe
every part of that was a lie. I don't have any money.
Maybe I was thinking about my wallet or somebody else's wallet. I saw a 5 somewhere and I thought it was Lauren's. I was mistaken. It's not deception, right? And I think she, the thing she hits on, which when you go back and look at the paternity case, it's so true. You need the medical provider to give the lawyers on both sides the actual medical evidence. So if there was a sonogram, for example, it needs to come from the provider and be sent to DSG and Woodnick or Corey Keith at the time or whoever it was. And I don't think that ever happened, right? Providers didn't send any sort of clinical proof of pregnancy. And that's what the whole, disagreement between Dr. Deans and Dr. Medchill was all about was there sufficient proof of clinical pregnancy? And for some reason, Dr. Medchill didn't seem to require clinical proof of pregnancy. He said, well, sometimes, you have a kid and you never get any prenatal care and then you leave with a baby. But of course, Miss Owens never left with a baby or any clinical miscarriage or anything. So that's where the problem is.
Yeah. If you guys, if you are new here and you've never heard about any of this, we're not going to be able to catch you up to speed tonight, but I will say this little bit here. So to provide some context, this attorney that we're talking about, David Gingras, he represented a client, Laura Owens, who in Arizona now faces 14 felony charges for running a serial fake pregnancy scam. She's actually, done this across multiple states and several victims, but 2 of them in Arizona, she now faces charges because she, victimized them with her scam. And this attorney represented her in one of her fake paternity scandal cases where she sued the Bachelor, the former Bachelor lead Clayton Echard, for, paternity of the fake twins that she fabricated, that she said she got pregnant by Clayton after a night of oral sex only. So he represented her in this trial and was like going to bat for her really hard and attacking everyone on the internet who was criticizing his client, basically insisting that she was pregnant. When, like, anyone with a brain cell knows that she was not, because like her former attorneys, several of her former attorneys at least, were just like, yeah, no, we're not doing this. We're not moving forward with this. This is not ethical for an attorney to move forward with this. And David, in order to move forward with her case while representing her as attorney and getting the notoriety of being Laura Owens' attorney in this high-profile Bachelor case, in my opinion, David played dumb on purpose. He refused to look at certain information on purpose. But when you're an attorney in an active case and you're taking Laura on as a client, you are required to catch yourself up to speed on everything that's happened in the case so far. But he instead tried to play dumb and say that was before my time. I didn't know at the time because it's been 2 years since we started talking about this stuff. It's been about 2 years now since he started representing Laura. I didn't know at the time that you couldn't just say, oh, that's before my time. I just thought that was stupid. I didn't realize it was against any rules. You know what I mean?
Well, Lauren, if he had tried to just sort of say, look, this lady needs to get to the hearing and make her case. Mm-hmm. And I'm going to go and do the objections and do the examination and cross-examination. You could do it in a way that I think wouldn't violate these things that the bar is claiming he violated. But you have to be like, don't put Dr. Dean's report on the internet.
Oh yeah.
Okay?
Yeah.
Don't make blog posts about Judge Mata or right.
But this stuff about not correcting the record and all that is pretty damning.
Well, yeah, you have to sort of say, we're going to put into filings only the things
Right.
that we've deemed to be legit.
Hmm.
So in my mind, you say, look, she goes and gives a lot of personal testimony about, she claims she had morning sickness. She has these photos of her stomach. She has these positive HCG tests. That's all you have,
Yeah.
really, for her case. And if you want to believe, you could say, okay, on the face of it, I think somebody's pregnant. But as soon as they accuse Clayton of being the father, then you have to sharpen your pencil and say, well, where's the real clinical evidence of this pregnancy, right?
Hmm. Yeah.
And so just let the court decide. If he had gone in and just said, look, this is all the evidence we really have, okay, and this is what my client said in a deposition, okay, and, I'm going to try and make it as correct as possible. You don't put in this thing about how she owns the $450,000 in a money market account. You don't ask her on the stand if she bought properties, because her mom actually bought the properties, apparently. So that's
a little up in the air on the who bought what at this point.
If you just play it real chill and just say, here's what evidence we do have, court, you decide. And I think you could have gotten her through it. Maybe. I would want, I'd want to hear a lawyer's take on that. Hey, look, we have one.
Yeah, hey Patrick, what's up? We were just talking about he was threatening to sue Megan over, what she said about he needed to basically just like ask her to sign a release to Planned Parenthood, and then if she couldn't show that she went to a doctor, that would be basically it. It was his ethical obligation to back off if she couldn't produce that, and he said that he was going to sue her for saying that, essentially. And so we were just talking about that to start.
Well, the way he characterized
people with that,
the way he characterized it was like, I'm going to make you get up on the stand, and I'm going to make you go through every single one of the things you said and prove that it's right or wrong. But that's not how defamation works. Like, you see it a lot in successful defamation cases where, I mean, I guess the Baldoni one would be a situation where they picked maybe two specific things and then they go forward on that. If David is going to try to plead, everything she's ever said, like that's not a defamation case. That's, I don't know what that is, but you have to pick the specific allegedly defamatory statements, right? So I know that wasn't where you guys were taking it, but that's what I took away from what he was saying, is just more caca.
Yeah, well, I have the what you were saying. I have the quote here where he was saying he's going to make her say everything. Okay, so let me read it to you. He says, I got a Google alert, I think yesterday or the day before, that Megan Fox released a video. Megan, are you begging me to sue you? Because if you're begging, your wish may be my command. Ew. Your little clip that you put out that said, did David know that Laura lied? And that was a question, by the way. He says, I've never seen an easier or clearer defamation claim. Every single thing that you said in that video was a lie, and you know it's a lie. And if I wanted to sue you in federal court here in Phoenix, I can. Is that important enough to squash an insignificant little person like you? It might be. I don't know. I'm thinking about it. I have a lot on my plate right now. I have like 3 or 4 more important things to deal with other than suing you. But if I have to, and if you really want me to, I'm more than willing to do that. I don't want to, but you seem to want me to. So it's frustrating, though. So getting back to the issue of settlement, how do I settle a lie? And okay, my personal opinion after reading that little rant there is it is totally on brand for David to think a woman is begging him to do something that she does not want him to do. First of all. Second, this is ridiculous. He even admits there that she's asking a question, and she's trying to determine the answer to a question. So it's just kind of insane.
I really hung on to the word it. I could do it, which I think he's not saying I could win a defamation case. He's saying I could make your life an absolute living hell. But I mean, vice versa, bitch. Like Megan could sue you for defamation. Like anyone can unfortunately or fortunately sue anyone. So obviously I don't think he was saying oh, I win slam dunk. I think it's more of a lawfarical threat of like.
That'll go over well with the courts, though, when he sues someone for defamation. If he's threatening them like that over something obviously ridiculous, like everybody has these statements that he's made. Good one.
I mean, fact of the matter is, while he has his law license, he can sue anyone that he wants. That's the long and short of it. Whether or not he can win really is not really even the point. I think for me, the point with any of his potential litigation is what's the fastest off ramp.
Mm-hmm. Okay.
Because I don't want to ride that ride.
Yeah. I mean, it works in a way, like his threats to do stuff like that. It works to scare some people, I guess. But Megan is not the one that you want to pick for that. So I don't know what he thought he was going to accomplish with that. Obviously, it didn't work out very well because she tweeted about this, like we were looking at earlier. So, yeah, he seems to pick people that like are just like, you know what, fuck off, do it or fuck off. Basically, like we're not going to sit here and like let you control everybody with your weird threats. And then he slinks back off into his corner for a while, posts a couple blogs about Donald Trump and how special he is for his dirty.com case, and then pretends it never happened. So that's kind of what we're looking at right now, I think.
Well, I guess he had a third case too. Don't leave that out.
Oh, I'm sorry. Was there a third one? That's totally my bad.
Well, he was complaining that people only thought he had 2 cases. So
who are these people that he's writing this for?
Yeah, that's a good point. There's 2 things about there's 2 things about his language that I don't really like. One is this idea that, oh, Megan knows it's a lie. How do you know what somebody else knows? Do you have like a written statement that they know, like a confession?
Because I don't think you pointing to one specific thing, it's hard to even know what he's talking about.
Yeah, exactly. But
I'm not going to do his homework for him. I feel like that's a Laura and David thing. Is like I'm going to half-ass it and expect you to do the hard work for me.
But Patrick, have you noticed this? Like Laura will do this too. She'll say like Clayton knew XYZ. Most recently with the $450,000 account, right? Clayton knew that was an investor's money market account, not mine.
Mm-hmm.
And to me, it's like, number one, you can't claim to know what somebody else knows, especially if you're under oath. What you should be saying is like, I told Clayton XYZ, because that's direct testimony. Do you find it odd that they do this sort of indirection with their testimony or with their statements?
I mean, I would imagine anytime they're under oath from now on, they are trying to be as evasive as possible. But it's an important like stylistic difference. Like I think it could just be from a lifelong pattern of deflection. You know, like I learned this in like Spanish class. Like there was like some Spanish culture where instead of saying like I dropped the egg, like the way the phrasing is the egg dropped from me. You know, it's like this learned behavior of I didn't do it.
You change the subject of the sentence. And that's the other thing he does a lot in these blogs and on Twitter in the past is he'll make the sentence subject like some label, like JFC says XYZ. And it's like, well, a label can't say XYZ. A human could, a commenter on Twitter could if you name them, but he and generalizing or being non-specific, it's okay if you don't if that's not the subject of your sentence, right? So if someone's like, oh, somebody in JFC sent me a document, here's the document. The document is what's important, not whoever sent it to me. So it's fine, right? But he makes these negative declaratives about JFC, like JFC. My friend told me JFC is too emotional. Like, well, how's a label emotional or not? Like, it doesn't make any sense.
I really looked at that little sentence that my friend told me, and I feel like that friend was telling him, like, dude, back off. Like, I didn't see that friend really being in his corner. I think it basically was just the way I read that was like,
fuck the corner. Is the friend in the room with us? Like, I don't know what's happening here, but he doesn't seem to have a lot going on outside of blogging.
I mean, it could be.
I don't really care about the generalizations. It's kind of like sticks and stones. It's like, I know who I am. I know my character, so I don't really care. But at the same time, you're saying it to the whole dang internet as if it were true. So I think it's still just kind of like he's still in this sort of PR mode where he thinks he can win the PR campaign. Like that's why I don't understand. Back to your point, Lauren, why are these blogs even who is happening?
I'm not really sure who they're for. I mean,
yeah, exactly.
This could have been an email because I've seen his emails. They're about the same length. It could have been an email to your friend. You didn't have to blog about it.
Or journal it. Just put it in a journal.
Because basically like the bar
pink diary like mine.
Oh, that'd be good. The bar is like his boss. It's like the HR. If he's a corporate employee, the bar is like HR department or something. And it's like if I had employees or if I was at a corporate job and I was blogging about my battle with HR, like why would anybody do that? Nobody would do that. If you're in a work situation, you just resolve it within the scope of your job. You don't make it public. It doesn't make any sense.
Right.
Yeah. I mean, every company, I mean, at least my company has the social media policy, you know, and so I'm sure there are, I mean, one thing that I think I would like to see come out of this is like that some type of ethical violation or ethical like framework or rule about, you know, public conduct that's a little bit more updated to this time because it's just getting too much.
Yeah. So I wanted to ask Patrick specifically about this, something else that he's been vlogging about, I guess, recently. I didn't watch the video, but I heard lots about it, and I saw some quotes about the settlement conference. Is it unusual for someone to talk about a settlement conference in their active case online?
Yeah, I would say as like, oh my God, it's so dumb. Like, why waive the privilege that you don't have? It's like, you know, the reason it doesn't make any sense is because offers to compromise and settlement conferences cannot be entered into the record like as evidence. Unless, of course, you talk about it publicly, in which case that privilege goes away, which is exactly what he did. So the judge can now, in their sentencing determination, the judge can now, what's it called? Look at that settlement conference, and he literally said out of his mouth, like, I'm basically wasting your time. He didn't, like, I'm paraphrasing, but he was like, to the settlement conference guy, he was like, we're never going to settle. He gives him some outrageous, like completely bogus settlement offer, and then vlogs about it. It's like
the way that he described it as if the guy running the settlement, like the mediator or whatever you call it, was looking at him like he was making total sense and he totally understood what David was doing, and like basically that he was like on his side almost, but not quite. But I was thinking about that and reading it, like what he said, and I was like, because somebody, you know, sent me a little bit of the transcript there, and I was like, this is how I would talk to in the past when I worked there, a delusional ER patient, because you can't just like make fun of them or be like, you're stupid, you know what I mean? You can't just like openly mock them, but like you have to kind of like just move things along and like keep the level of trust there and just do your job. That's kind of how I would talk to a deluded patient.
The vibes I got was kind of like good cop, bad cop. Because if this Jim, you know, bar guy is the bad cop, quote unquote, then maybe the mediator's the quote unquote good cop, you know, and they're just trying to get the witness to confess to their crimes.
Yeah, I've been in mediation before, and it's kind of like not really in the lawyer's hands. Like it's all, and the settlement person isn't really, they don't push too hard. I mean, unless it's a private settlement, like where you have
the mediator's not pushing hard.
Right.
Yeah, that's been my experience too, because I was in a mediation and I felt like, what are we paying this guy for? He's not like pushing on anything really. Like I had to like be real, ask him to go do something.
Yeah. Oh yeah, of
like,
course.
Go find out XYZ. And,
I just realized we haven't given any context for this conversation, so I will real quickly just recap what has happened. So a lawyer, David Gingras, was charged by the Arizona bar with 6 counts of misconduct. He filed a very lengthy response filled with very interesting quotes to the Arizona bar, defending himself on multiple grounds. because of some of the admissions he made in his answer, the Arizona State Bar moved for judgment on the pleadings related to 2 of the counts. Specifically, one of them was disparaging comments he made about a judge, and the other one was posting medical records of his client online. Attorney Jingras denies any wrongdoing in this situation, and he's presumed innocent until proven not to be. But at this point, he has gone on a vendetta-esque rampage against the Arizona Bar for what he perceives as, I guess, some type of cabal or conspiracy against him specifically by unethical people who work at the bar, at the judiciary, and everywhere else. And I think the bar posted the most recent document was he filed his answer, and then the bar filed the motion to end the case, and then he filed a response to that, and then the bar filed a response to that saying why he was wrong and how they should continue to move forward with finding him guilty.
Yeah, and the part of that, is that this here?
Is that the document?
Oh,
So this is the most latest document from the
'Cause
bar.
I wanted to ask Patrick about this.
Yeah, I don't know if there's anything specific you wanted to jump to, Bruce. I wasn't going to read the whole thing, but
I haven't seen it yet.
To me, there was a part in here where they mentioned how, respondent's motion contains significant information wholly irrelevant to attorney discipline cases. And later on, they're talking about, it seems like he's trying to relitigate the paternity case or the appeals of the paternity case, to be specific, I think.
Yes.
More than the paternity case itself, more like the appeal process.
I was saying this to Lauren off stream, like he's making multiple different arguments. Like the way the law works is a pleading has to have one subject matter, one set of arguments. He's making multiple different arguments in various pleadings. It's so confusing.
I think one of the quotes you were alluding to is this one here. I don't know if you read that kind of fully, but as explained more fully below, respondent failed to offer any relevant legal basis to defend his actions and instead argues he would rather continue litigating the dismissed underlying state court cases in this attorney discipline matter. So
I don't blame the bar for stating that, because if you go back and read his pleading, like it's borderline indecipherable as to what he is asserting as a defense to the motion.
You mean like so his actual? I know his actual answer was kind of insane, but his response to the motion for partial judgment on the pleadings was also, I think, I was just kind of like, what are you doing here?
I think
this
isn't
isn't relevant.
Explain that in order to, I mean, I love when he like tells the judge, like, hey, this is mandatory, you have to do this. I love when he does that. I bet judges love nothing more than to be told what they are forced to do.
Okay.
Oh boy. Yeah.
Oh God.
Maybe he should reach out to the judge's father. That would probably help.
Yeah. I mean, I'm sure he will file CJC complaints against every single person. A CJC complaint is a complaint against a judicial officer, against anyone involved in this case. I love how he just like completely dropped off that he was going to like get the interview of the appellate judge that ruled against him.
Yeah.
You know, he was like, he hasn't said anything about that. I'm like, yeah, because you realize you'll go to jail for harassing a judicial officer.
Right.
But yeah, some of his stuff was basically like, to overcome the judgment on the pleadings, he has to prove that there are that there's a material issue of fact that they have to go forward with discovery. Because basically, judgment for motion on the pleadings means discovery hasn't been completed yet, and there's no need for discovery because it's so obvious what the outcome should be.
Right.
So he really needs to overcome this hurdle to be able to get discovery.
So you have to like to try to like put it in terms that a dumber person like me could understand. Not that I'm like dumb, but you know what I mean. Not a legal person.
Right.
So there's no way that he could overcome the law, even if he got evidence to support what he's saying. It's like the law itself is basically saying that he would lose based on that.
Which law?
So whatever, just like in general, a judgment on the pleadings is like, even if we went through discovery and got evidence of what he's trying to like say and his weird like irrelevant arguments, it's like he admitted to doing XYZ, therefore he cannot overcome, the law there, and he can't win that based on like whatever he's going to come up with in discovery.
Oh yeah, so that's the bar's position. The bar's position is we don't need to do anything else. He has already admitted, and we should move on to like mitigation and stuff, because maybe like the things that he's saying about, I've read posts about the judge online that talk about how she has committed misconduct in other places. Like maybe that could be a mitigating factor into why he said what he said, but he's routinely said, I believe what I said was true. He said it in the pleading as well. So I don't think he's going to be able to overcome. Right. Basically, if he does get, so let's just play it out. If the motion for judgment on the pleadings, and then he responds, and the judge says, okay, yes, we'll go forward with discovery. What he asked the court to do was to turn the motion for judgment into on the pleadings into a motion for summary judgment. I don't know the rules for summary judgment off the top of my head, but I have to assume that it probably occurs after discovery. So that's sort of why it's all about the discovery. Like it's all about getting the discovery.
Right.
And to me, an interesting legal issue there is he tried to get Judge Mata's records from her directly, and then he tried to, or from the CJC. He tried to get it from the place that investigates judges, and they said no, and the court said no. And then he tried to get it from Judge Mata personally, and the Attorney General said that he's basically just trying to use a go-around to get something that's already been denied to him. And I was like, that's a really good point, but I don't know if that's not proper or not. It's certainly scummy, but I'm not sure if it's not proper.
I mean, you can do that though, right? Like if one person is, the court says you don't have to get something from one person, you can still get it from another source. It's just
futile unless they cooperate with you. Is that right?
Well, unless he gets that motion to compel. I mean, you could subpoena someone, and
they could just agree. Judge Mata could just give him whatever he wants.
Yeah, I agree. But I mean, the thing is, people aren't going to do favors.
If they don't want to do that, then it's just futility, right?
I think so, because that actually makes a lot of sense. That reminds me of like Aaron Brockovich, but that makes a lot of sense. Where it's like, okay, yeah, you can go get this evidence from someone else, but you can't subpoena them and use the court to do it, because then the court would be facilitating you backdooring the process. Like the court already ruled you're not entitled to this information, so you can't use the court again to try to get the same information. If you get it voluntarily, that's another thing. Maybe that's why he's trying to get the roving room subpoena.
So let me ask you this. So they asked for the quick judgment because he acknowledged that he did certain things, and you mentioned it was primarily about the medical records and the
MATA,
the medical report from Dr. Deans and the medical records. That's number one. And number two is the Judge Mata thing. Let's say the Judge Mata thing went away and it wasn't a problem. Wouldn't he still have this problem with these other things that they had in their original? What was that list we read through, Lauren? It was like 98 different things of. Wouldn't he still be kind of in trouble?
Oh,
or would it be like less trouble? Or is he just trying to minimize things at this point, or what?
Well, they had their settlement conference and they offered him 6 months and a day. So if something gets dismissed, maybe they'll have another settlement conference.
Oh, okay.
But I don't see that happening. I mean,
you think he'll ask for more than $250,000 that time?
Now, here's my next question. He mentioned that 6 months and a day is effectively disbarment, because once you go past 6 months to 1 day, there's a different process you follow. Is he correct there, to your understanding?
Yeah, I'm glad you brought that up, because I want to point out that is like materially false. It's not a death sentence at all.
It's not disbarment effectively. I think that's what he said. It's
No,
effectively disbarment.
No, I mean, it is if you're lazy, but all you have to do, if it seems like
I know I am.
well, honestly, you could also just hire a law firm to do this, but I mean, I'm sure he won't do that. But if the law as he tells it, and I'm not sure I even believe it's correct because he's saying it, but he says that after you've been suspended for 6 months and 1 day, you have to reapply to the bar. It doesn't even say anything, and so that could mean either you have to take the bar exam again and you have to reapply. And people think that you just take the bar and become a lawyer, but that's not how it works. You have to fill out what's called the character and fitness investigative application. And you have to fill out things like, have you ever filed for bankruptcy? Have you ever been arrested? Have you ever cheated in college?
What if you get a second DUI? Does that?
So you guys kind of see why he may interpret it as a death sentence.
Oh no!
Yeah.
If you dress up in a Home Depot outfit,
if you have a gun behind you while you talk about a judge, it may be hard for you to pass the character and fitness.
Or like saying you had it outside of the courthouse while you're complaining about the judge. Yeah.
But in absolutely no way is effectively disbarment. That is only something that a lazy person who has serious concerns about their ability to reapply, whether that be for, lots of different reasons in David's cases. I'm not going to speculate as to which ones would be the biggest issues for him, but it's not disbarment.
I mean, just to be devil's advocate for him, if he's planning on moving,
don't do that.
He's doing his new roof. He wants to move, right? If he moves and you have to wait 6 months, well, I guess less than 6 months and 6 months and a day are kind of the same at that point. I don't know. Like, it's effectively like you're dipping out anyway.
I mean, you could still apply.
To be fair,
you could still apply from wherever you move to.
Oh, so you're saying he could move to Northern California and still be licensed to practice in Arizona?
Yeah, I'm licensed in several states, and I applied to one of the states when I was not in that state.
Very good. Okay.
Mm-hmm. So no, it's just laziness. That's why it's a death sentence for him, because he's lazy. But you could also just hire someone to do it for you.
I'm trying to help the guy out, but I'm not getting very far.
Well, to me, it's like I would not want to lose my law license because, hey, I took that bar. I worked hard, to get that. I paid all my dues. Like, it's...
Oh, yeah. It's non-trivial.
Yeah. So, I mean, there are people who would rather maybe just walk away. I'm not sure what other form of revenue stream he would pick up. But anyways, like, I wouldn't walk away from, my whole profession.
Right.
Unless I was lazy and knew that I wasn't going to pass the character and fitness background.
Yeah. Let me see. I'll go through some of these and I'll pull up. Jay Down, thank you for $5. Can we put up the Afro Man signal and send him in the direction of DG? Well, I'm going to do my best there. Auntie M, thank you for the 5. If DG sues Megan, will you ask her to play the musical in its entirety, please? I'm sure I wouldn't have to ask her. I think she would probably just do it. Jupiter James, thank you for the 5. I love when the gang gets back together again. Oh, thanks for stopping by. Appreciate it.
Thanks, guys. Yeah, I've been busy.
Emily Laura Wilson, thank you for being a member for 1 month. Listen to Davey G. Bloviate and make empty and truly pitiful threats has run its course. Almost not funny anymore, but I do enjoy their cajoling. Yeah. So this, hold on, how do I take that off?
Someone asked if a practicing lawyer could pass the bar, and yeah, absolutely. There's multiple courses that just teach you like the tips and tricks. And then also the lawyers that started graduating in like 2015 and beyond are idiots, like certified idiots.
What?
Why?
Just look at the bar passage rates historically, like since 2015, like really bad. And
you're saying more people are failing?
I'm saying Gen Z is not good at law. That's what I'm saying.
Oh, it's law is too skibbity. Ohio.
But because of that, they have lowered the standards quite a bit in terms of, in some states you only have to know federal law, you don't have to know state specific law. There are still other states that are really difficult.
What is this about a universal bar exam?
Yeah, exactly. What is about that? I didn't get that option.
Yeah, I was wondering about that because I heard about it and I was like, "Excuse me, there's a whole universal?" I thought you had to go like state to state if you wanted to.
I am 99.9% sure that's not a thing.
Okay, because I keep seeing something about it, but like, mind you, I see this on like Reddit, so I don't. I've never really looked into it, but
I've looked into being a lawyer in a different country, and I would have to at least get my LLM. I don't know, it's a master's in law. I'd have to get my LLM in that country in order to take the bar, but I wouldn't have to go to law school.
Oh, I thought the universal bar exam is like all states or whatever. I didn't know. I think it was like.
Oh, maybe they're talking about the multi-state bar exam, the MBE. Yeah, the bar is split into two. Usually, when I took it, split into two days: state-specific day, and then federal. Well, it's called multi-state day.
Okay.
And that one is more standardized. But now a lot of states are just using the standardized one.
Yeah.
Multipass.
So we have this here from the bar, and this is their reply to the judgment on the pleading. So they put the thing here where he says he knew that the February 21 court order said, "Let the record further reflect that no party shall disclose outside of themselves any medical or other documentation, exhibits, medical record, etc., disclosed between the parties." And then it says, despite his actual knowledge of the court's prohibition, respondent nevertheless filed a motion attaching a signed declaration, posted Sonora Quest Labs medical records online. He also knew that opposing counsel informed him of his violations of the court order. Despite his admitted actual knowledge of the foregoing, respondent repeatedly violated the unambiguous prohibition. He posted a bunch of stuff online. I'm not doing word for word here. Filed another document which included medical records and excerpts from medical expert reports. Posted a copy of his filed document online with the medical records and excerpts from the expert reports attached. Let's see. Let me skim down here to where they said.
And all he said in his defense, was, well, I did a bad thing, but the other lawyer did a bad thing too.
Right.
And look, right here, I mean, we're gonna read it, but
whataboutism is not a defense.
Yeah, it's not. It's just,
and I recently rewatched. I was watching a stream. They were rewatching the June 10th hearing, and with the June 10th hearing, with the time constraints, right? Time management was very important. And of course, a lot of people don't think Jingras did great time management. But as I was rewatching it, I noticed Woodnick was asking Dr. Deans, did you expect to see your report on the internet? Did you see your report on the internet? He's asking her these questions. I'm like, why is he asking her this? Is he just dunking on Jingras? But to me, it's maybe this good foresight of Woodnick, because he's creating a record that supports what's happening right now, which we could never have predicted, but I guess maybe he did.
Yeah, that's a great point. I didn't realize, I didn't pick up on that, but you're totally right. And maybe that's what gave the bar the confidence to charge him, because it's on a court record.
Yeah.
They wrote here, as to respondent's second claim, incredibly, respondent, an Arizona lawyer of almost 22 years, suggests the plain and unambiguous language of the order that he admitted he was aware of is simply too vague to be understood, as it did not contain the words "it is ordered" or use language specifically sealing the prohibited documents.
I remember that. I was like, David, magic words aren't a thing. Just do what the judge says.
Right.
Him saying that was another thing he blogged about, where he blogged about how his experiences dealing with liars shapes his perspective on the world. And I was like, this is a really good juxtaposition to compare a reasonable person to an unreasonable person. And in the law, we use a reasonable person standard. Right. And I was like, what's fundamentally different about David that makes him unreasonable? And I think it's pretty clear that it's that he assumes the worst in people. And I think that this was sort of an aha moment for me as a lawyer, was because what is a reasonable person? And I think if I had to define a reasonable person, they are probably, they is this mythical person, believe in government regularity and believe people unless there is evidence to contradict what that person is saying. Like that's what I believe a reasonable person is. And in the case of Judge Mata, using that type of person who assumes that, you know, I guess how would I frame it in the case of Judge Mata? Can you guys help me out? Like, how would a reasonable person interpret Judge Mata's actions? Oh, we've done this before. Like, she could have made a typo. It could have been that she had a personal experience at Planned Parenthood that gave her that knowledge.
Well, I always thought that, for me personally, she was asked to take notice of his blogs before the trial, and before the trial, like well before the trial, there were comments about Planned Parenthoods being closed on Sunday, whether or not that was correct or not. There were comments that stated that well before the hearing in his blogs that she was asked to take notice of. And since we can't actually access like all the exhibits that they put in there that they didn't end up using at the trial, and their like pretrial motions, we can't see all of that. So I'm like, I have no idea if there's actually a comment in your blog that she was asked to like look at that you know says something like that. So
yeah, I think to me it's more when you have a question and the intellectually honest answer is I don't know. Like, why did Judge Mata put this sentence in this ruling?
Sure.
My answer is I don't know. Right?
It's weird.
And I think his approach is, let me speculate and create a zoo of possibilities. Is there one that suits my case? I'm going to assume that's the most likely answer then, because it suits me the best. And he rolls with that as if it's
more accurate
almost
description.
Conflated with truth, you know, a statement of fact versus an opinion. So he sort of creates this gray area between speculation and a statement of fact. And it's this imprecision, which you can see littered throughout his writing, that I find very, it's a signature, if you will.
Yeah, that's a way better way of explaining his psyche. It's not that he's inherently distrusting. It's just that he is going to create whatever narrative in his head he thinks is right, and then distrust everyone who doesn't support that narrative.
Mm-hmm. Yeah, and there's terms for this. You know, there's like the sharpshooter fallacy, where you just, you know, when your arrow hits the mark, you count it and you don't count anything else, or you know, confirmation bias, or you know, these type of things.
All right, let me move down here to, it says, well, respondent attempts to justify his unapologetic violations of his professionalism and ethical obligations. He suggests that his misconduct is constitutionally protected. The Arizona Supreme Court disagrees. So this is where they're talking about standards for lawyers, like when it comes to First Amendment rights versus like regular people. It says a lawyer is held to a narrower standard of free speech than a non-lawyer when discussing the judiciary. And I think Patrick maybe could explain that to people in a way that's easy to understand. Why is that? Like, why exactly are they, or what exactly are they held to when it comes to like talking about judges and stuff online? So what's the different standard?
This is actually like a really complicated rule. Like, the issue is, what can a lawyer say publicly about a judge, and without like and what's protected by the First Amendment and what's not. And from my reading of that case, it's just really complicated. But the one thing that I picked up on that applies to Jingras is that a lawyer cannot speak about a judge during an active court case with that judge, or in any way that has the ability to impact ongoing or future litigation. That was like the one hard and fast rule that I read through these.
Right.
So I think that would be the narrower standard. You can talk as much shit about a judge. I mean, because I think it's a fundamentally American to say, I disagree with that judge's decision. Like, I'm good with that all day. And even to a certain extent to say it during a live piece of litigation. But once you start crossing into the, and this judge is, you know, racially biased. And during active litigation, you're tainting the jury pool and you're undermining the integrity of the judiciary. So it's, you know, there's a very small subset of speech that's covered here. The only problem for fucking Jingras is that's his speech.
Well, two follow-ups, Patrick. Number one, there was no jury in this case, right? It was family court, bench trial, bench hearing. Number one. And number two, does that rule that you just described apply to the appeal process? Because I think that's when he started really going hard on the judge, right?
He tried to change, he did the motion for change of judge. He started to fuck around with that. So, I mean, I guess it was before the appeal.
Yeah.
I believe it's actually in Riley, which is why Riley is such a complicated case. They actually found him in violation of his ethical obligations because of exactly your point, because the statement that he made could have been overheard by the judge in the appellate case and influenced the judge in the appellate case. So Riley is a really interesting read. There's like there's a concurrence and a dissent. So it's a long read, but it really lays out, it really tries to walk the narrow path of what's protected by the First Amendment and what's not. And it all really hinges on, don't even have to worry about the jury. It all just hinges on, does it diminish the public's opinion of the court in general, and specifically the judge who's presiding over the active case. So you don't even have to get to the jury for him to already be really in hot water here.
They mentioned there, in taking the oath of admission to the bar, lawyers swear they will abstain from offensive conduct as well. What is this related to? Do you think this is related to the Reddit stuff, or what is this? Or just the statements about Judge Mata?
I think it's just a general, like just stating the general rule that you have to not be an asshole. Rude, attacking comments reflect poorly on self-regulating
profession. Yeah, all right. Yeah.
Lauren, he called us TFPAs.
Yeah, I think he's called me a little worse than that, but
total fucking psychos. Is that what he called us?
Yeah,
psychotic
right, yeah.
asshole.
David just keeps on giving.
I try not to say it because if I say it, Omar will come on and then his kids will hear me in the background and I'll feel bad.
I have to say though,
it's so rude.
The thing he said about Melania Trump, like I mean, I have my own political beliefs, but like to speak about a woman like that, like
I think he's talking about the blog yesterday, Patrick. Is that what you're talking about?
What did he say?
I will pull it up because I don't want to read it, but I'll pull it up.
Okay.
And then I'll read it, I guess.
Okay.
I
didn't read that blog.
Well, I mean, look, if we need to pull up examples of him saying rude things, or what was it? What was the language? Demeaning language, or like if we need examples, we can come up with examples all day long.
Well, this one's from literally yesterday, so we're gonna go.
Well.
Yeah, okay.
But it was
till midnight if we write them all down.
It happened like right on the heels of him writing like another blog about like a woman and protecting a woman, and I'm like, was it just too much for you to be nice to women for like one blog post that you had to like make it worse somehow?
Melania Trump was begging for his attention, obviously.
What? Oh no.
Okay, let's see. Honestly, in the year 2026, it's this kind of photo is this kind of photo really shocking? He's talking about the photo of that he defended the woman who was like partially naked, and she might have lost her Miss USA crown because of the photo surfacing. I don't think so. For fuck's sake, there are tons of pictures online of the person I just said with her tits out and legs spread, looking every bit the Eastern European hooker that she is.
Yeah.
What?
Okay. So like
that is so unnecessary.
You said like you
What
said
the heck?
before you read that, like you have your own political beliefs or whatever, but just think about this. Like David would literally talk about pretty much any woman like that if the woman was somebody he didn't like. I'm pretty sure. That's my opinion. But he talks about women and talks down to women in a certain way that makes me feel like Melania Trump was not a special case there. She just happened to be the person he was talking about at the time. That is a very strange way to represent yourself on your law firm blog.
Right? Oh my God, such a good point.
It's terrible. Even if we ignore the sexism and the rudeness and the inappropriateness, it's still just whataboutism. So even intellectually, it doesn't convince me of anything.
Mhm.
You know what I mean? Like, it's just a bad intellectual argument.
It just made my mouth taste bad.
Yeah.
Like, and
Yeah.
like, why make that comparison? Like, it's just sometimes I feel like when he needs to generalize, he specifies, and when he specifies, he generalizes.
He's driving the wrong way down the one-way road.
Here on the number 3, they mention another case where it says a relentless campaign to malign and embarrass opposing counsel and the judiciary is clearly prohibited conduct. And obviously he's still doing that even in these bar case filings. I don't know if that matters related to the charges, but
I think it's going to definitely go to, because what Jingras has not pointed out to us yet is that the disciplinary law judge has full discretion.
Okay.
Right. Like, they can do whatever they want. So they could see that and say, no, I'm recommending disbarment, like, or no, 2 years. Like, so.
Wow. Okay.
Keep yapping, bro.
I mean, the stuff that they charged him with was bad enough, but I feel like his responses have possibly made things infinitely worse. I was just like, I'm not sure how much is going to be considered about that, just because I've never seen anything like this before. You know, I don't follow this kind of stuff normally, so I've never seen a bar case in my life. I've never like followed along with a bar case, so I don't know how much that was going to matter. But at the same time, it was like, oh, buddy.
I mean, do you remember on Twitter when he said he thought the bar guy was cognitively impaired? I feel like bar guy should file a bar complaint, but I don't know who he'd file it to.
I know, jumping for bar guy on that shit's crazy.
Yeah. Well,
like, just don't say the thing. And then, then the whole anti-slap situation, like, I think that's also pretty much doomed to fail. So David is saying that at some point he is going to affirmatively sue the state bar for violating his right to free speech. So basically, by punishing him for his speech, he's saying that violates the protection of speech law.
But that's not an invocation of anti-slap, though. That's separate, right?
Well, my understanding of anti-slap is that it only deals with actions taken by the executive branch of the state or the federal government. It doesn't deal with actions taken by the legislature or by the judiciary. So,
which is where the bar is.
Which is where the bar is. You said this months and months and months ago because you were confused about, like, what is the organizational structure?
What's the jurisdiction of these entities? Correct. Yeah, we talked about that.
Yeah, and I said I thought it was. I think I said at the time, I thought it was probably quasi-governmental, but I was wrong about that. It was judicial. And then I said, because it's judicial, you might not be able to file a public records request, but that also turned out to be wrong. So I'm glad to be wrong on both those counts. I did graduate before 2015, but I still seem to be wrong.
I always thought anti-slap was like a defense. And the way you're phrasing it, it's like he's going to mount an offense, which to me would not be congruent with anti-slap.
Yeah, he's thinking about the damages portion only, which is why he's characterizing it as a sword and not a shield. In reality, it would be twofold, right? Like, you can't punish me for what I did. That's the shield. And now you owe me damages for punishing me. That's the sword. But he's only focused on the damages.
Don't you have to get to one before you do the second one, or do you just do them concurrently? I don't know. He's arguing in his motion or his response that you can't do a sword and a shield to protect Judge Mata's information.
Well, he'd be able to claim economic damages. Damages aren't discretionary. Or those economic damages aren't discretionary. And then I think there's something called treble damages. Basically, you can get, like, whatever your economic damages is, like, triple it. And some anti-slap statutes have treble damages as well. So
right, they were asking for that in the other case, right?
So basically, if we just limit what he's saying to economic damage, he's saying $250,000 is basically how much money he lost because of this in 1 year.
Because of work he's not doing or something? Or what? Because I know he mentioned time lost, taking time away from work. And I'm like, how many clients do you even have at this point, bro?
Yeah, like what would he have really been doing?
Do you have enough time to make videos about me? How many clients do you have?
I'm guessing he's doing like remote doc review.
Maybe. But does that really warrant $250,000 a year? Like that's...
No.
I feel bad for his clients.
Oh boy.
All right, so we're down here. This was not a very long document. Like I said, I didn't want to go word for word, but it says respondent's general beliefs and reasons. He suggests the motion should fail for 3 separate reasons. 1, multiple material facts are in dispute. They say the opposite is true. All the relevant facts in support of this motion were unequivocally admitted in respondent's answer and amended answer. And then they put the footnote down here that says an admission in an answer, so like a true or admit, is binding on the party making it and is conclusive as to the admitted fact. No evidence may be shown to contradict an admitted fact. And so I took that to mean like if he admitted, but then he did all that weird explaining and shit that he did in the answer document that's not really normal to my understanding. Like none of the weird explaining that he did matters. Is that true?
Yeah, you just have to stop reading after admit.
Right. Admit or deny or neither admit or deny. Something like that.
Yeah, it's either admit, deny, or state that you don't have sufficient facts to admit or deny. That's what I was always taught.
Yes, no, I don't know.
But in his answer, he's accusing people of crimes and shit.
Yeah, he engages in some whataboutism in some of his responses. He tries to rationalize a little bit. It's some of that like, okay, I broke the law, but it was for a good cause, or so in his mind, right? Because he's judging himself by the intent, whereas the bar is judging him for his actions.
And his response to that was, if you look at what I admitted to, I didn't admit to anything that is a factor in the things I've been charged with. But clearly that's not correct if the state bar saw his response and said, yep, we win.
Yeah, I mean, it's sort of like if you're in a corporate job and HR is trying to fire you for something, and you say, well, it didn't ruin the project I was working on. They can still say, well, your work conduct is reason to fire you, right?
Yeah, absolutely. The bar's prediction is contrary to controlling law. Wow. Yep, he did say that.
I mean, that's... all right. The respondent repeats the following in various forms throughout his response. Prior requests for confidential orders in the underlying case were denied prior to the February 21st order. The language of the orders is too vague to be understood, which is just... Yeah, I mean, it's interesting that he feels the need to call himself that fucking dumb, in my opinion, that he didn't understand that. Opposing counsel also engaged in misconduct. The state bar is violating the anti-SLAPP law. Okay. As to the first claim, courts are authorized and frequently do alter, revoke, amend, affirm, overrule, clarify, and reverse orders throughout the pendency of lawsuits. Prior rulings, which were later negated by written order, do not provide a defense or other justification for respondents' knowledge and repeated violations of the valid February 21st order. As to his second claim, incredibly, respondent, and I think we read this before, an Arizona attorney of almost 22 years.
Wait.
Oh boy.
That paragraph right there is about how he says, oh, it was denied. The request for confidentiality was denied like 3 times, using that as a mitigating factor as opposed to, okay, I get it. Yeah, I get it.
But does that matter in a motion for judgment on the pleadings?
No, not at all. What matters is, did you have actual knowledge of the ruling?
It's sort of like saying if you have a big circle in a Venn diagram and you're not counting that, and there's a slightly smaller circle and you're not counting that, but there's a very small circle and you are counting that, it doesn't matter that you got rid of the first 2 big circles. You still have the tiny circle, which is what the judge said, and they're saying, like, if you can't understand that, what's wrong with you, sir? And Lauren, do you understand the parallel here between this paragraph and the bankruptcy case where Laura Owens claims to not understand the difference between the owner of an LLC and being the manager, or the difference between gross profit and net profit, and just starts claiming complete incompetence as a defense. And here we are in this paragraph with equivalent parallel. Who could have predicted?
Well, the problem with that is the incompetence thing is that with David, especially with Laura, maybe it's a little more excusable because she's not an attorney. But with David, he wants you to believe he's both incredibly stupid and the smartest person in every room he's been in. So it's like doesn't really make any sense.
Well, she was saying she's the CEO of these companies, but she doesn't understand if she has an interest in the LLC or where the interest would be documented, which is equally unbelievable to me as this argument.
I make $200,000 a year on the stand, but then she's like, no, what? I've never made income in my life.
Exactly. Yeah.
This is David logic.
I love this paragraph here.
Which one?
Someone went through a lot of trouble to write this.
The order suggests that the plain and unambiguous language of the order is simply too vague to understand that it did not contain the words "it is ordered" or use language specifically sealing the prohibited documents. Oh boy.
It was his job also to review that hearing, though, right? Where she clearly and unequivocally claimed or like orders them not to share things outside of the parties. And he had to review that. That was his job.
We had plenty of videos on. He could have watched it on the internet.
Well, we know he watched them. He just only listens to the convenient parts. All he does is sit around and watch this shit. So,
oh boy.
All right. As the respondent's third catch-all claim of wrongdoing by others, the named complainants and the potential witnesses are not parties to this attorney discipline matter. So,
yeah, I mean, no whataboutism, right? They're not buying that argument.
I don't understand why he did that. Why he accused Greg Woodnick of a crime in his response. I was just like, I don't think that's going to make you look very good.
I think it's more misdirection. Like, don't look over here. Look over here instead.
Yeah, that's going to go really well. I'm sure. None of these beliefs are accurate or state a legal dispute to the motion. Okay.
Wow.
Yeah, that's about it. Respondent has admitted the relevant actions and fails to provide a legal dispute that his actions complied with the Arizona rules of the Supreme Court. Therefore, an evidentiary hearing on the admitted facts and resulting violations serves no purpose. So they don't even want a hearing. Okay.
No.
According to the State Bar request, the court enter a judgment against respondent for his violation of the cited rules. So they say we don't even need a hearing. You should just rule in our favor. I mean, I guess maybe it's normal for them to ask for that. I don't know. But, you know.
And also note, this isn't just the one lone bar guy, right? This is
somebody else.
This is the senior bar counsel. Right. So again, at some point, right, you've got the Judge Mata, you've got the appeals court judges that are in a different county, right? They're in Mesa or wherever instead of Maricopa. But and then you've got all these people. At some point, it's not that there's a grand conspiracy and everybody's out to get you and you're the only one who knows the truth. At some point, you just have to realize you're not right. And
hey, Steve, what's up?
And you have to move forward in a healthy way and stop fighting or just find a solution. I don't know.
I wanted him to just take whatever the plea was, and
6 months in a day.
6 months is nothing.
Yeah,
6 months is. He could be back in a year because the background investigation takes a while, but back in a year.
Yeah.
Well, his I guess thing is like, I won't plead guilty to something I didn't do, and I'm like, but you did do it, and you said admit to all of these things. So like, I don't.
I know. That's why I was like, why is he writing all in his answer, he made legal arguments. He offered like mitigating and impeachment evidence. He was introducing evidence. I made sure to check. Was actually citing case law in his answer. And I'm like, that is not what this is for. And I think that, someone needs to hold him to, I'm surprised we haven't seen a motion for a more definite statement in any of these cases, because these people, Laura and David, need to be reined in. I mean, not necessarily because they're bad people, but just because they got a lot of thoughts. And like the law has to work in a certain way for us to be able to address those thoughts. And you can't just throw mud at the wall and expect us to clean it up for you.
Some things are only meant for the blog, dude. If you really want to go that route. I mean,
what are you saying, Patrick? Are you saying that the processes should be interrogating them more? Is that the idea? Or
people should be holding, you know, people just want to be done with them, but there are lots of mechanisms to like actually narrow this issue and make it clean.
Okay.
You know, motions to strike, motions for more definite statements. You know, there's also like discovery conferences where you can have like a plan on, but people don't want to deal with him. So I think what this pleading does really well is it cuts through all of, you know, the bullshit, the declaration, all of it, and just says what's objectively true based on the pleadings. And then they're going to leave it, and I think this is the right thing to do. They're going to leave it to the judge, say, hey, this is our position, and this is David's position, and your call. And I think that's all you can do with people like this. And I feel bad for the judge.
I've seen in chat a lot of people likening this to these wacky sovereign citizen things that tie up time in the court and things like that. It sounds like you're on that sort of avenue.
Yeah,
right? And there's not a good remedy here. Whereas I think in the bankruptcy case, maybe there is, because they have the federal bankruptcy attorney who's like, well, okay, you're saying XYZ, it doesn't make sense. Let's do a deposition and get more information.
I think he's actually, it looks solves it because of just the volume of communication, but solves it is a specific type of wrong.
Yeah. It's sort of like you're really interpreting a lot of laws very, very incorrectly in a specific way, right?
Yeah, I mean, my favorite is when they like just cite to various USC code sections, like as if they apply in state court.
Yeah.
My favorite soft sit is Queen Romana of Canada. If you guys want to go down a rabbit hole, go down the Queen Romana rabbit hole.
I want to move into the last thing I want to get into tonight is this second motion to compel. But he tried to send a subpoena to Judge Mata and her father. Eventually, they did both get served. They separately filed objections to those subpoenas, or not objections, motions to quash those subpoenas. And then rather than respond to their motions to quash, he has now filed a second motion to compel, combining them both. And Patrick, if you could explain a little bit about like what you thought about the motion to quash by Judge Mata, particularly because I didn't ever go over that in like YouTube stuff because I was busy covering Afro Man, so I didn't get into that. But I know that you had read it and had some thoughts about it. And also, I'm going to be off the screen for a second while I get some more water, but I will be right back.
Yeah, the response to the motion to compel, the response filed by the AG's office, if you read it closely, it is a pretty magnificent takedown. It's like how lawyers say to go fuck yourself, but in a much nicer way. I'm trying to pull it up so I can get some quotes, but I was just like, damn, that but he posts so much. And all of his posts are nonsensical, so I can't even sort them.
I think the thing, with this bar situation, we finally have a little bit of back and forth we can analyze, right? We have the bar response, his response. In the beginning with all this bar stuff, it was just his blogs and his motions. And I felt like we couldn't get both sides of it, right?
I mean, that's why we need all these documents, is because I agree. You can't really assess. You certainly can't take what he says on his blog to be correct. Like that's why, I think
you can talk about it, but to me, it's just not newsworthy, right? It's like, well, what is the process hasn't taken a step forward. So to me, him blogging 3 times a day or something, I just don't find it newsworthy. You know what I mean?
I completely agree with you.
Too much noise to the signal ratio.
Yeah, I mean, you have to take it sort of like I just described with the state bar and the judge. It's like you have to wait for everything to come out and then, you know, make an assessment. But reading like the deluge of blogs is not helpful. Like I can't do it anymore. And you know, the videos are somewhat helpful, but only helpful in the sense that they're inculpating, which I feel bad about. But it's like no one is listening to this for anything other than reasons to like make sure you lose your law license. So why you're doing this, you know, it's not really my call. I'm still trying to find the response. Give me a second.
Yeah, I mean, he's sort of arguing to the wrong crowd, right? Like the court of public opinion does not have any bearing on your situation with the bar. Like we're not gonna, like, even if I agree with him, oh, the bar is wrong. So what? It doesn't help him to blog about it and have me on his side. I'm not important.
I know, at all. Like it doesn't help at all.
Yeah. Where was the appeal, Patrick? What district was it in?
Which appeal?
You know, the paternity case appeals. The 3-panel judge.
Oh, 2.
What jurisdiction was that in?
Tempe? No, Phoenix.
It was in Pima.
Oh,
Tucson.
Boy.
Right?
Was
they
it
had to move to Tucson?
Tucson?
Yeah. Because
I gotta go look it up now. I can't remember. I thought it was
not where I'm from, but I lived there for a couple of. So he was like, "We're moving it out to Pima." I was like, "Well, I know where that is."
Because he was all happy about that they had the overflow problem and they had to move it to the next zone over or whatever, and it didn't work out for him anyway. But I just thought that was interesting.
Well, it moved because of volume. I think someone said at the time it moved because there was just too many cases in District 1.
Exactly. Yeah.
I thought they wanted it to move. I thought he asked for it, but that's
no. He just said it would be good because I don't know.
Okay.
I'm trying to find the AG's response.
I have it right here.
Oh, you do?
Ooh.
Yeah.
Yeah. How long is it? It's 12 pages.
Yeah, we can just skim through.
Yeah. There's some really good like this. Okay, so first, what I want everyone to what I wanted to comprehend was, okay, so these are his requests for documents 1, 2, and 3, and the Attorney General takes it in order. So first, she's going to talk about like why 1A through H is improper. And I just thought that was like a helpful way to write it, because really 2 and 3, you know, are pretty summary. It's mostly 1. Okay. Gotcha. I'm sorry, 1 and 3.
No, all good. Okay, so she asked for, or he asked for correspondence, including emails, texts, online chat from all these people.
He asked for everything.
Yeah. Copies of any documents you sent or received from any person, including but not limited to notes of any other written material. Yeah. Copies of social media posts made by you related to or which mention any of the people or matters above. Copies of any social media posts you reviewed regarding these people, or any minute entry orders, ruling, or decisions issued by Judge Julianne Mata during any time which contain the word snake or python, which is the robing room thing. Yeah, so they were saying Judge Mata is a non-party of this action, is a sitting judicial officer. It seeks multiple categories of court records and other documents related to a case he litigated that she presided over. It's presumed that the state bar documents referred to is a bar complaint filed by Judge Mata regarding respondent Jingras. Additionally, the reference Arizona Commission on Judicial Conduct, the CJC complaint, is that which respondent Jingras filed against Judge Mata and was the subject of this court's March 11th order to quash portions of the subpoena, and March 12th order motion for relief.
That I want to know what that is. I could not figure out what that was.
Shocker that he would not post those.
Yeah. Well,
post everything else.
The order for motion for relief. I wonder what that is. Maybe that's another. I don't know what that is.
I don't know either, man. No idea.
Yeah.
Yeah. What motion for relief? I mean, what would that even mean?
Motion, I don't know. Motion, I mean, it could be motion for relief. I don't know. Like maybe it was another subpoena.
Yeah. Well, in an effort to eliminate potential confusion, all document requests will be addressed herein with this. Yeah, blah, blah. Okay. Public policy favors protection of judicial integrity and dignity. I don't think we need to like read through all of that. What would you basically sum that up as? What does that mean?
Just that he can't read into her judicial thought process.
Right. You can't force the judge to explain their line of thinking behind their rulings. Is that?
Yeah, his response to that was idiotic. He was like, I win automatically because she is not going to be able to testify. It's like, no, what she's not going to be able to testify about is her judicial, her thinking while she was on the bench, while she was drafting the opinion. That's what she's not going to testify about. She can testify about the fact that you were waving hand signals at Laura. She could testify about the fact that she was sent, your blog post calling her a criminal. Like, she can testify to all those factual things.
Right. Okay, so we'll go on to the next thing there. Let's see. Oh my God, that was a long one. He continues to seek CJC records, which is, I think you mentioned that earlier, where he's trying to get those records where the court even said, like, they don't have to turn that over. And I think we might have had a conversation about this a few weeks back. It feels like it's been forever now, but it hasn't. Where I was like, the CJC, their policy technically says they can turn these things over, but they're not required to. Mm-hmm. And why would they want to work with him the way that he's lashing out at everybody and acting unprofessionally and unreasonably? Like, why would they want to turn that stuff over? And it seems to have bitten him in the ass.
Yeah, you were saying it's like, why would they want to give him something that he could use to harass someone? Like, why would the state do that?
Yeah. Megan says, am I being threatened again? Well, no, it's just, it's the most recent threat. I just had to go over that first. So we went over that earlier, though. Don't worry. I mean, maybe tomorrow. There's always tomorrow. Okay, so he's already sought such records from the CJC in this court and has been denied. The court is in the best position to determine what, if any, release is appropriate. Okay. Respondent seeks to harass Judge Mata while fishing for information, which seems obvious.
That's a strong statement, isn't it?
Yeah, I mean, it's definitely true, though. I mean, he had the guy waiting for her at the courthouse. Like, he could have had her served, I guess, at her home, like she had her father eventually served at his home. I don't know why he does things the way that he does, other than to play the victim and be like, they're refusing or they're ignoring or whatever. I'm like, dude, he texted her father, which is fucking unhinged, after like harassing her, the sister. Like, he has harassed both of this man's daughters. Maybe he has more kids, I don't know, but like at least two of this man's daughters, and like sends him a text message, which is fucking creepy, and then a letter to his house, also fucking creepy. Like, if you absolutely need to subpoena someone for a court process, just do it the way that you would go about, like in a professional manner. Like, just send the process server to the guy's house, have him accept service, whatever. You didn't need to text the man or like send letters to his house. That's fucking weird. And then, with her, what? Go ahead.
I was gonna say the bar here is also calling him like stupid. Like, what you did, you could have you didn't have to bother anyone for this.
Right.
Where it's like, respondent Jingras has offered no legal citation to warrant the release of information from a non-party, nor has he indicated that he cannot get the same directly from the state bar.
Right.
To the extent such information is relevant to the proceedings, Jingras should obtain it from the state bar. Like,
right.
Like, why are you bothering these people?
Because he doesn't just want to like win this case. He wants to have her like nailed to a cross or something. It's insane.
Yeah, that is not the way to approach litigation.
No, and it's also just like a sign of like emotional attachment, an unhealthy emotional attachment to all of this. It's like, this is so personal, and you're not even paying attention to the law or the courts or the rules. It's so personal.
This footnote is interesting, that the subpoena was recalled or modified.
The subpoena presented to Judge Mata was drafted prior to this court's decision regarding the CJC subpoena, but it does not appear to have been recalled or modified since. Huh?
Oh, it wasn't recalled or modified.
Yeah, they're calling him dumb again. They're basically saying, you knew, like this is an ethical violation in and of itself. The subpoena presented to Judge Mata was drafted prior to the court saying that you couldn't get the same records that you wanted from the CJC. Okay. And he hasn't called it back yet. So basically, he has the subpoena that's out there right now is already in violation of a court order.
Yeah. I read it backwards because I'm dumb.
At least we're expected to be dumb.
He's like one of the smartest people I know.
Let's see. The extent such information relevant. We saw this part. We won't read, like I said, all this word for word, but to the extent the state bar.
Kind of juicy. She does call him dumb a bunch. It's pretty good.
Yeah. Well, additionally, the extent the state bar has already provided disclosure, limiting additional disclosure to between the parties will eliminate the duplication of efforts and, if any, minimize unnecessary non-party involvement. Item 2 seeks personal material sent to or received from Harry Howe and or Meredith Howe, Judge Mata's family members. This is insane. It's insane that you to like go to the judge presiding over your case and be like, show me what you said to your father and your sister. Because your sister follows a reality star on Instagram, so you must be a corrupt piece of shit. Like, what the hell?
It's such an appeal to emotion kind of argument. It's not an argument made out of factual evidence of misconduct, right? Like, ooh, the judge has a family member who has an Instagram account. It's like, so what?
So what?
The judge's father was there. We saw the video, right? Oh, the judge's father was here. I said, we'll get him some scones. Like, it doesn't matter. Like, and he wrote this blog saying, oh, I brought my mom to my court hearing, and I realized no judge should ever have a family member there because the pressure's too much. Like,
he wasn't even in the room. He was in the overflow room. He wasn't even with us in the room.
What is this appeal to emotion kind of argument? This is not a convincing argument to me.
It's rhetoric. That's all it is. If I were reading this, I would just be like, it's rhetoric. I'm skipping it. It's like, you know. I think one thing that's phenomenal, what's shocking about David is he has changed the reasoning behind why he thinks all of this is nefarious, but he's never once been willing to consider changing the actual conclusion of his thoughts.
Right.
It's always other rationale that supports the conclusion. It's like you need to have a flexible mindset. The conclusion is not always what you think it's going to be.
Yeah. We've seen that before. He's very inflexible about that. When Reality Steve and Rachel Juarez were grilling him about, why did you say there was no way in hell you were going to lose the appeal and then you lost the appeal? Maybe you shouldn't make declaratives like that. And he's like, maybe. But he keeps doing it in these recent blogs about this case. He's making declaratives just like that. So he has not learned.
My favorite was when he changed his entire legal strategy based on something that Rachel said. And then he's like, Rachel's so dumb. Rachel's so dumb. She's so ordinary. Let me just change my entire job based on what she said.
That's the kind of dumb I want to be.
And put it in an appellate brief.
You're right.
And this is another takedown right here by the state bar. Respondent Jingras has made no credible offer of proof as to the existence of anything.
Wait, where is that? Down here?
It's line 12.
Line 12. Okay. Item 2 seeks personal material, blah, blah, blah. He's made no credible offer of proof as to the existence of anything. Right. On its face, this appears to be a fishing trip. This appears to be a fishing trip in an attempt to find anything that fits within his theory of his case. Further, given the number of subpoenas issued, oh God, Mr. Gingras appears to be casting a wide net in his search for information, but does not limit it to known existing information or appropriate information sources, suggesting that the real purpose is to harass subpoena recipients until he gets what he wants.
Yeah.
Sounds about right. So he subpoenaed
thousands of years of recorded human history, Lauren. 8 billion people on the planet, and he's proved nothing.
He's proved absolutely nothing. I can't.
The CJC, Harry Howe. Okay, so we got CJC, Mata's father, the MCSO, Judge Gary
And it just
Fox is
goes back to
appealing
laziness.
and
I'm
Judge
sorry, I
Miller.
have to go back. He is so lazy; it infuriates me. Like, if you want to prove these things, file a no. You know what? No, I'm not.
Don't
No.
give it to
No,
give it to him.
No, I stop it. No. I might go microwave some chili, actually.
Okay.
Yeah, if you're gonna get advice, you might as well get paid for it.
I'm not giving that motherfucker no advice.
Yeah. Okay. Regarding the social media information requested in 4 and 5, Judge Mata avows via undersigned counsel that she is not aware of and has no responsive documents or information. So he's like dead set on this like social media stuff being the reason behind her decision. And she's like, yeah, no, I swear to God, there is nothing responsive to that line of questioning. So I don't know what you want me to do. Yeah, I won't go through the whole thing tonight just because I want to kind of get through some of this here. And I don't want to take 3 hours to stream, but this court has 3 discovery motions to consider. He says the motion to compel and 2 motions to quash. These motions may appear at first to raise simple discovery disputes. In truth, the outcome of these 3 motions will have a major, almost certainly dispositive impact on this case. And so he's basically saying like the outcome of these subpoenas is going to make my case. But the thing is, like, whether or not she has documents responsive to this stuff, it kind of seems to me like it doesn't matter if, you know, that part of the ruling, which we've already established is not critical to the ruling, like whether or not Planned Parenthood was open on Sunday because she wasn't pregnant. But like, it's not like that critical to the ruling. But even if he's able to prove that she made a misstatement based on a social media post or made a statement based on a social media post, it's like none of the rest of the ruling is something that he can really dispute. Yeah. And like his violating the order is not something that he can dispute. He admitted to it. His using information that was incorrect and not correcting the record is something that he can't dispute based on this. There's so much stuff that's not even remotely related to this.
Yeah, and Lauren, you don't even have to go to whether or not Laura was pregnant. Right. She could be pregnant or she could have not been pregnant. Planned Parenthood as an entity never sent an ultrasound to Woodnick and Jingras or Woodnick and Corey Keith.
Right.
So you're just done at that point. The pregnancy is irrelevant because no provider ever sent a record to the lawyers. So who cares? Mata could have put, 5 + 4 = 12 in her ruling. Who cares?
I've heard that's correct.
I mean, the new math. I don't know.
Yeah, so there's just a lot here that's like, I don't think this matters as much as he thinks it does. But
yeah, and Omar makes a good point. Judge Mata is not on trial. Gingras is.
Well, he's doing a miserable job of he's not defending himself at all. He's just attack. I'm like, you have to defend yourself. Get a lawyer.
This is why at the top of the screen, when we looked at the bar's response, they were saying he's litigating the original case in the appeal. He's trying to put other people, Woodnick, Mata, whoever, on trial, but that's not the issue here.
It's just so embarrassing when you really think about the big picture here. The fact that he's going through all of this and he's crashing out the way he is over someone who was obviously lying about being pregnant. And he can't use the before my time excuse anymore when it comes to this stuff. It's like, she was obviously not pregnant. She obviously lied multiple times about when and where she got an ultrasound. Nothing she said was true. So the fact that he's still like doubling down on this stuff and attack, it's just like, it makes him look like such a fucking dumbass. It really does.
Yeah, I mean, he's going after these side quests, if you will, right? Because the whole paternity case is done, right? It's cooked.
Yeah.
What can you do? So the only thing he has left, he has to respond with something. So he's going off on these different side quests, right?
No, he thinks he can get the paternity case reopened if he just gets his magical evidence.
Well,
yeah, I've heard that.
So convoluted.
Oh boy. I mean,
dumb.
I don't
know. What do you guys think is going to happen if they reopen that paternity case and they redo all that, knowing now that Laura was fucking some guy at the same time she claimed Clayton got her pregnant from a blowjob?
Oh my gosh.
How do you think that's going to go? She lied about having sex with someone else while this was all happening.
Can we redo the paternity case and bring in the MCAO investigative report? Because I think it'll be 2x the fun, Lauren.
I think poor Nicholas. I would hate for him to have to be a witness in that. But
I know.
I mean,
I wish nothing but peace for Clayton from now until eternity.
Yeah. Wow.
Yeah. I mean, it would be sort of it would be 2x the fun in this intellectual perspective. From a real world perspective, this is all just insanity.
No, that's not gonna work.
Well, it's not gonna work.
I was gonna say maybe we could like put David in the place of Clayton.
That's not.
That's not.
What?
I don't want to watch that. That'd be such a mess.
Oh
my god, there'd be like traumatic to even read what happened. Those two would destroy each other. Anyways, to avoid confusion before discussing other issues, it is important to be extremely clear what this motion is not intended to do. It is not intended to act as a veiled attempt to get the court to change its prior rulings regarding records respondents sought from the CJC. Oh, this point is important, so it will be addressed first. I don't really want to fuck with all this, but I will. 2 weeks ago,
yeah, because the AG was saying you're just trying to do this in a different way.
Right. So the PGJ denied that motion on March 11th. Needless to say, David did not share the denial of his motion because he only shares things that he thinks are going to be good for him on his blog. And then he's like, well, people only look at one side. Well, you're only publishing one side, so nobody really gives a fuck. In that order, the court quoted from the bar's complaint, which accuses respondent of making false statements regarding a judge, Julie Mata. After quoting the bar's allegations, the court summarily stated respondent Jingras has not demonstrated how the outstanding items in the subpoena would assist in his defense regarding such. Because it's not going to assist in his defense, because like what she said in her response to his subpoena was that we don't have anything responsive to this. How is this going to help? So, yeah.
Why is he all of a sudden talking about the bar? He was just talking about the attorney general. Like, it's all over the map. I called that it was going to be like this.
Later the same day, respondent moved for relief from the order denying the motion to compel. What does that mean, Pedro?
Respondent moved for relief from the order. Oh, basically he wanted the judge to reconsider the denial.
Gotcha. In that motion, he asserted the PDJ's decision appeared to have been based on argument that was never raised in the CJC's objection. For example, that the records in question were not relevant. Whatever, dude.
The judge can say whatever he wants. The judge is also the judge is also the fact finder in this case.
Yeah.
It's weird to argue for a remedy when there's no consensus that there's a problem that needs to be remedied. Normally, the remedy term is for something everybody agrees. Like, oh, the jury heard something they weren't supposed to hear. We need a remedy. What's the appropriate remedy?
And also, it's not relevant. It's not relevant at all because the PDJ already ruled on, presumably on his motion for reconsideration. So bringing up, hey, by the way, I think you were wrong. What you did earlier is not. So he basically. First paragraph took issue with the AG. Second paragraph took issue with the bar. Third paragraph took issue with the judge. Got it.
They're all wrong, sir. Don't you know?
Let's see. Respondent then explained the records were plainly relevant to the issues of whether his comments about her were true or false. Respondent explained truth/falsity is a central issue in his case because, as multiple courts have held, attorneys may be sanctioned for impugning the integrity of a judge or the court only if their statements are false. Okay.
You only get one bite at the apple, motherfucker. You can't bring up new arguments.
Didn't he? Okay, so somebody asked that the judge review these documents. I think it was the CJC in camera, right?
As an alternative form of relief.
Do we have any evidence as to whether or not the judge did that?
No, I don't think they would do that unless without issuing.
It just kind of seems like. Honestly, to me, that kind of seems like a quick way to get him off her back, though. So I kind of feel like that maybe they, but I know that it's kind of like maybe that's not a normal process. I don't know, but
no, it definitely is. Like that's why they offered it as an alternative form of relief. They said you should deny this, but if you don't deny it, then to the extent you do allow documents in, you should review them first. So it was a very sensible way of handling it. And at that point, the judge can review the document and say, no, you don't get this. It's not relevant.
It just kind of seems to me that that's what they should have done, because that would nip this shit in the bud so fast, and now they're gonna have to keep dealing with this guy. So I'm like, maybe we should have done that in the first place. You know what I mean?
Yeah, when you're the state, you just have different considerations like policy and precedent. So I agree with you. Like, just get it done over, like go over with. But I can also see the other side of it.
Right.
Yeah, I think in terms of information, you're right. I think in terms of process, though, you want to be careful. Is the point?
Yeah.
You don't want to get too stuck in your ways. Like, one of my least favorite things to hear at work is, well, we did it like this a couple of years ago. It's like, well, it was illegal then, and it's illegal now.
Omar says, wow, so Jingras is getting nothing he asked for. It kind of seems that way, but he's still trying. He's still trying. All right. After respondent explained the records were relevant, the following day on March 12th, this court issued a second order affirming the court's position that respondent was not entitled to obtain records from the CJC. Okay.
Oh, I love it.
Yeah. In that order, the court explained respondent's point about relevance was misplaced. I need to see that order. Otherwise, I can't trust anything he's saying because he lies all the time.
He doesn't even quote things properly. That's the scariest thing.
No, he like leaves huge sweeping issues out. It's like, you cannot believe anything this man says. So unless he wants to post the entirety of that order on his blog, I can't even believe any of the arguments he's making. All right. In that order, the court explained respondent's point about relevance was misplaced, for example, because they indicated the motion to compel was not denied on that basis. Well, yeah, that's kind of a big deal. Yeah. The court further explained the order to quash granted relief because of the confidential designation that the Arizona Supreme Court has given the documents in question under the CJC rules. To be very clear and to put this as politely and respectfully as possible, well, that's first. Yeah.
I can't.
Respondent disagrees with the court's legal conclusion. And this is the way that he should be disagreeing with things all along. But now it's too late. In his prior pleadings, respondent noted confidentiality is not a valid basis for withholding otherwise relevant information. And then he quotes here a case that says there's no absolute privilege for trade secrets and similar confidential information. But this quote here in this case, I don't know if it's really the same circumstances. You know what I mean?
Yeah, I don't think that's like a judicial process for family courts.
An attorney disciplinary proceeding. Yeah.
And also that quotation right there is, only for comparative analysis. It's not like declaring that what.
It's not a precedent.
Right.
It's not it's a persuasive precedent, but it's not a controlling precedent.
Yeah, there we go. Okay. I don't even know what those two things are, but I think I understand.
The Supreme Court agreed with this rule in Cornet Stores versus Superior Court, blah, blah, blah. In that case, a party refused to answer interrogatories on the grounds that they asked for information of a highly confidential nature. The Supreme Court rejected the argument and held confidentiality was not a valid basis to withhold otherwise relevant information in discovery. Instead, the party or witness holding confidential information must produce it subject to a protective order if warranted.
That's the key, right? If warranted. Also,
Right.
Who is the requester? Or who are they requesting it from? Are they requesting it from a family court judge? Like, what is the context here? We all know Jingras likes to cite these cases that don't have direct correlation to his argument, right?
Yeah.
And there's probably like a specific code section that talks about, like, that defines confidential information in the context of evidence, which that seems to be. But what we're talking about is a statute or a law or some type of regulation.
Mm-hmm.
So they're completely not comparable.
Yeah, it's apples and oranges because we don't have the if warranted yet.
And so it makes almost all these highlights and underlines and bolding irrelevant because it's like, none of this matters.
He cites the United States versus Nixon, which I think he wrote a blog about that recently. I saw the headline, but I was like, I'm not fucking reading that. So the very integrity of the judicial system and public confidence in the system depend on full disclosure of all the facts. Well, okay, so for me, and I'm only reading this underlined portion here without reading all of this stuff here, just reading this like quote that he is emphasizing. I'm like, the very integrity of the judicial system and public confidence in the system probably also depends on lawyers not making baseless accusations of federal crimes against judges presiding over their cases. But that's just me. So
this is the only point that I agree with him on, but not for the reasons he states. Like this case, Nixon is citing like the balancing test that occurs when you're weighing whether or not to disclose confidential information.
Sure.
And the question is there an overbalance in favor of the public knowing this information, such that, like the Epstein files, perfect example.
Right.
There's a strong need for the public to know this, that regardless of the confidentiality at risk, it needs to be released. In the case of Watergate, I would say there was a pretty compelling public interest. In the case of, the reason I agree with him is because I do believe that the conduct of judges, the conduct of the entity in charge of regulating judges is important for the public to know. I agree with him on that. The problem is that when you are making that type of argument where you're attacking an entire institution, you have to show a pattern of these types of weird, I guess, denials. Like, is it every single time someone requests a CJC record, the CJC denies them on confidentiality grounds? Or, and if you can again, more laziness.
Or can you explain why it matters? Like, I understand why getting the Epstein files matters. I don't understand why getting Judge Mata's thought process about why she put Planned Parenthood in her ruling matters at all, because it's irrelevant.
So David would say, well, the public has the right to know if judge, and that's why he's also subpoenaing the roving room, because he's trying to establish this pattern. So predictable. But he would say the public has a right to know if judges are Googling things and as part of their decision-making process. In reality, what he really means is I have a right to know because it makes me look like less of an asshole.
Yeah.
So
yeah.
he has.
He's not the public, though.
Exactly. The foundation is improper.
Yes. He's effectively in a biased position. This is like the converse to the appeal to authority that I was arguing with someone in the comments. Well, not arguing, but discussing, right? He's basically got this biased position, right? So I don't buy his argument from authority because his answer has an effect on his case. He's not neutral. He's not neutral.
Yeah,
that's the problem.
You don't think he's neutral?
When he makes an appeal to authority saying, I'm a lawyer in Arizona and other people aren't. Yeah, because you represent Miss Owens. You're a biased authority.
Hey, Omar, what's up?
What's up, everybody? Hey, I'm testing out my new microphone in Cancun. How's it sound?
Nice.
I was asked if you were okay because you were supposed to do a live stream the other day and you didn't. So.
Oh,
Omar, I've got people DMing me asking me if you're alive, if you exist. Like, what is going on?
I'm definitely alive. I got real busy and I was getting ready for this vacation.
Oh, good. Yeah.
And in the midst of prepping for that stream, which I'm still going to do, by the way, I had to travel with the girls. And so I'm still alive. And yes, all of those things. I'm not dead.
Cool.
So how about that?
We're very glad.
Yeah. Okay, so you've been listening to some of this stuff. I don't know if you've been following along with any of this.
The last 10 minutes, yeah. So I'm gathering that Jingras is getting nothing that he asked for, and all the things that he has been ranting about, which are so important and so integral to this process, apparently is not, because the issue is whether or not he's conducted himself appropriately, not whether or not Judge Mata did himself wrong, and not whether or not he can revisit the merits of the Echard case from 2024, which is kind of like with everybody. You don't need a lawyer to point that out, but that's seems to be the route that we're going.
I don't know. It kind of seems to me like he's in the right here. So, just saying.
Good luck. He's about in the right as much as your hair is in the right.
Fuck off. My hair's to the left. On the screen, at least. Anyways.
It's getting long.
It is, yeah, I know. There's only so much you can do when it gets to this point, right? Like, I tried
It's
to
in
grow
the
it out.
awkward like phase.
I tried
It's
to,
like
I tried to grow it out once before it got to about this long, maybe a little bit longer, and I just like fuck it, and I gave
you
up.
gotta do something with it, man, until it either grows out or cut it all off again.
That's what I
I
did
say
last
go for
time.
the cabbage patch, like right on the top.
I'm not familiar with that.
Oh, I'm so old. Never mind.
It's
Keep
like a
reading.
front ponytail.
Oh boy.
No, basically make your bangs a ponytail. Oh, actually, that.
That's what I said. Front ponytail. That's
Yo,
more
you should
like
lead with that. You straight up were curly from the Three Stooges.
You look like a cabbage patch kid.
Now you're selling us.
now we're getting closer. Now we're getting closer. When it goes in the front, it's
Okay,
more
I
like
support
the
that.
emo style,
I don't know if I want to be emo.
the goth style. You could
Oh,
be a
boy.
goth.
Give it your best Sum 41.
Oh, okay. Well, Sum 41 is a little irrelevant now, so maybe I don't want to look like them. You know?
Who? What?
You don't know who Sum 41 is, Bruce? Yes, you do.
What? Who?
Sum 41?
6'7"? What?
I was gonna say 6'7". I'm
I don't
not
know
lost
who-
than anybody else.
No,
What?
Sum 41, they sang that like graduation song. That was Sum
No,
41.
man.
Someone
That's
says
not helping.
Fountainhead. Ayn Rand.
All right, whatever. We're done with this. Anyways, we're moving on. Moving on here. He's talking about Nixon. We're moving past that. Having said this, to avoid any misunderstanding, respondent is not asking the PDJ to revisit, reconsider, or otherwise change the 2 prior rulings relating to the CJC records. Okay, good for you, I guess. Here's why the subpoena issued.
Well, he had to underline that, right? Because he'd be in trouble otherwise. Is that what I'm picking up?
Yeah.
Well, I guess he's just emphasizing that he's still not asking. He's not asking the CJC again. He's asking Mata and her father. So,
You know, having examined David Gingras' pleadings for like 2 years now, this is him on his best behavior. This is the most defeated I've ever heard him sound in a pleading that I've read anyway. Like he's up against it, man. Not even in his appeal brief. At least there was like he was giving it the old college try. This is like he's just defeated, and he feels.
Yeah.
You just see it in his prose that he is a defeated man. There's no recourse for him.
Well, he asked to quit and get $250K because I guess he needs a down payment for a condo somewhere or something. I don't know, but they wouldn't give him his $250K, so I think he's in tough shape, man.
oh, guys,
How
I
do you
got
supposed to
Green
get
Day and
250K? What's
I
he
got
getting that
Green
for?
Day mixed up. And
that was during the settlement conference. He said that would be how much money the bar would have to pay him for him to give up his law license.
Yeah,
Like,
let's do that.
ironically, also as much money as Clayton or Laura owes Clayton.
Oh, nice.
Oh, I would like to think that those two are not related.
Yeah.
Both those two are not related.
Okay, so Green Day and Sum 41 are not the same, guys. Just letting you know.
boy.
Oh, 741 is a band? That's not like
Oh, boy.
No, Sum 41 is a band. They have that popular song. It's like I want you to know, where they want this go.
my wife doesn't even know who that is, and she listens to that kind. Oh, never mind, she does. I
totally does.
take it back.
There's a song
I
called,
sure
it's called
do.
"With Me," and it's like a really popular song, and I keep getting them mixed up with other.
If you
people.
were
And
in
also,
any
Simple Plan,
American
I get mixed
mall
up too.
in the I said if you were in any American mall or American Eagle in the mid 2000s, you heard that everywhere.
Yeah.
You want me to
Well,
go to
not
the
on
mall?
purpose, and it certainly didn't make any impression.
No, you don't need to go to the mall tonight, Bruce. That's okay.
I can get one of those pretzels.
Oh, Auntie
Yeah.
Anne's. Oh my God,
shit.
so good.
I would buy a
Hey,
ticket to
here's
the
a
airport
question:
just to get
Is
some
there
Auntie
an
Anne's.
age? Is there an age where it's inappropriate to go to the mall? Like it's cool to be at the mall, like in
No.
your 20s, right? But
You can always go.
in
mall's
between
not
ages
for
of like 35 to 50, I feel like you shouldn't be there.
No, you can always go. Go to the mall.
Yeah, you go to
There's
the mall.
something to do. You can go look at the you can go look at the Rolex shop. You can go look at the what's the blue wall with the lights. You can look at the Lego store. They don't judge you for looking at the Legos.
I don't
feel
know.
like
I just feel
all-
like
I judge
All
you.
bets are off in Thanksgiving and Christmas. I think at 30 to 50, those are the only times you're allowed to go. Or if you're on the way to the movies and you have time to kill.
well, I guess like if you're not if you're like going by yourself and not like with somebody, or like with your family or with your kids or something. Like if you're just a guy like hanging out at the mall,
You're going
you're
to the
like,
mall alone?
I
I'm
would
facing
not.
this exact
What-
dilemma
what-
right now because
What
I
kind
want
of
to go
lonely
see.
life are you living? You just go to the
I'm
mall
facing this
alone.
exact dilemma because I want to go see Project Hail Mary, but I don't have anyone to go with. So
Oh,
I'm
just
like,
go to. Yo, let me tell you something, man. Going to the movies by yourself
Yeah.
is the best.
I go
That's
to
a
movies
movie.
alone.
That's not
I'm
the
all
mall.
for that.
Those are two
Not the
different
mall.
things.
That is the movies.
I go
And
to
if you're
both
going to the mall
alone.
for that purpose, I guess that's okay.
No, go to the mall alone and then go to the movies after alone. It doesn't matter.
I'm just going to the movies. But I was like, I was in my head, I'm like, are people gonna think I'm a weirdo? And then I was like, no,
I go
that's
alone all the
me
time.
thinking it.
A lot of times
I
I'll
just
go to
think-
movies that have been playing for a while just so nobody else will be there. It'll just be me. Like, me alone.
No, I'm a big fan of going to the movies by yourself because there's no better way to watch a movie. Like you get the movie experience and you don't have the distractions of being with somebody else. You get like the full real deal. Like you're there for the movie. It's a way to watch movies that you're not going to get anywhere else.
All right, you convinced me then. I'm gonna go see
Yeah.
Project Hail Mary by myself.
Do it. No judgments anywhere. And if they do, then they could,
Yeah.
not to
I
be
feel
the
like-
one to curse on Lauren's stream, but
Omar
need
has successfully turned this stream into Flad.
Okay, I need to move through the rest of this so I can go to bed. Anyways, he says that Judge Mata is not, the court's not ruled on this, blah, 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 whether or not she's complied with the subpoena. He says basically that the confidentiality rules provided a valid basis the CJC to withhold the information. He respectfully disagrees with that, of course. And then down here, he says the court denied respondents' request to obtain records from the CJC. It did so because the rules say records held by the CJC are confidential. Judge Mata is not the CJC, and her motion to quash does not claim she's entitled to withhold information on the same grounds as the CJC. While respondent respectfully disagrees with the PDGA regarding their prior rulings related to the CJC, Judge Mata is in a different position. As such, this court should reach a different result. It should order her to comply with the subpoena by producing all evidence that is relevant and non-privileged. Okay. The same is true with respect to her father, basically, he's saying. So instead of, Omar, I was telling them earlier, instead of responding to Judge Mata's motion to quash and her father's motion to quash, he filed a second motion to compel about both of them, which I'm kind of
wait. So he filed a motion to compel, and that I guess got denied, and so he just filed another one.
No,
he served them with a subpoena.
I get it.
Both Judge Mata and her father, Harry. And then Harry and Judge Mata filed, motions to quash the subpoenas because they were served separately. And he's now filing a second motion to compel, I guess.
Both of them.
No.
No.
Yeah.
So yes, actually, yeah, you're right.
Yeah.
What was the rulings on the motions to quash, though?
They haven't been ruled on. Oh,
We don't
yeah.
have
Right.
them yet.
Oh,
Right.
okay. So we're just going to have this all pending. That's so Jingras' style. Let's just like make everything pending on the same day and confuse the shit out of everybody. It's like a very simple issue. He's issuing subpoenas. They don't want to comply because he's asking for stuff that's not relevant. And while we're waiting for that, he filed a subsequent motion to compel. But a second one, you said? So I guess he's already had one denied. Am I missing that? Or am I getting that
We're
right?
missing that information, but I
He
assume
doesn't tell us everything. Like, he doesn't tell everything. He acts like he's being transparent, but then he doesn't share everything. He doesn't share the things that look bad for him.
Well, the motion to compel being dismissed doesn't make a lot of sense if the other stuff is still pending.
It's
Right.
all confusing.
To me, anyway.
it doesn't. It doesn't make any sense. I don't think it should be considered by the court. It doesn't make any sense.
Mm-mm.
Well, the motion to compel would be premature if they haven't litigated the motion to quash. Wouldn't just,
That's a good point.
They haven't
procedurally
done any of
speaking,
that. I think they're just sitting there waiting to see whether any of it's relevant or not.
I don't think any of it is, but
I mean, I'm trying to.
Mhm.
I'm reminded of who the litigant
Go
is. I
second
mean, I
up
guess
here.
it makes sense in that regard. I'm just saying that usually when there's a motion to quash, it's ruled upon, and then if it gets denied, and then the party still doesn't comply, then you do a motion to compel. I don't understand the motion to compel.
okay. So it says
At this point.
here motion to compel second. I don't know if that's because he filed a different motion to compel in a different subpoena, but This court has 3 discovery motions to consider, this motion to compel, and 2 motions to quash.
3 discovery motions to consider. This motion to compel. Why does he keep doing the intro with the M dash? It's weird. Compel.
ChatGPT.
Because ChatGPT wrote it. But so yeah, there were 2 motions to quash, and then there's a motion to compel. But we don't know the outcome of the motions to quash.
No.
I actually would buy that AI wrote this because this doesn't sound at all like David.
He doesn't. It's very respectful.
That's what I mean. It's not
like him at all.
I'm not sure if he's. I don't know. He's so fucking dumb.
You don't have to get a ruling on a motion to quash. The motion to quash for Chase J. Jones was never ruled upon because I think it was improperly.
Well, something can sit hanging out there, for years and years, and the case can get fully litigated and never ruled on.
Yeah.
And not to get too bogged down in that. It's just that when you file a motion to compel, it's because remember when there's a process, you usually have to meet and confer with the other party and address with them what you want them to produce. But it seems like with the motion to quash, they responded to it with a motion that should be ruled upon before any consideration to a motion to compel, unless their plan is to like trail it. I guess maybe it's something like this. Because it's premature. If they grant the motion or don't grant the motion to quash and order her to comply with the subpoena, then they trail the motion to compel to some future date pending some future. I'm getting way too far in the weeds. This is stupid. It's premature.
Stupid. Yeah, it's premature.
That's what she said.
Okay. Anyways, it says both subpoenas seek relevant information. I'm going to kind of skim over this stuff. He again is like trying to use screenshots from Instagram accounts that he tries to say that this Instagram account is not accurate. In his recent blogs, even he like pointed out something in the Instagram account was like, this is not accurate or true. But then he also tries to put screenshots from this Instagram account and be like, this is definitely evidence that my claims are true. And I'm like, what is your problem? You got to pick one or the other. Like my opinion on that is irrelevant. You have to pick a side and stick with it. Like it's kind of stupid.
That is so inappropriate to include in the filing. You should have put that as an exhibit. The judge already said to do that.
Oh
yeah. Well, he keeps putting pictures of us in there. He's got pictures of me in like Rob's case. He's got pictures of me in Mike's case. He's got pictures of me everywhere. He's got pictures of probably Omar places too that he shouldn't have them. He's got pictures of Megan and Dave and Mike in these filings. Now he's got pictures of the Instagram account in these filings. He's like, can you not just like leave other people out of it and defend yourself? Like nobody's really doing anything related to your case. Like this Instagram account posting stuff about Judge Mata's dad is not related at all to whether or not you violated ethical boundaries of your profession. Why are you doing this?
Well,
I don't understand.
Also, he's like arguing against his case with this exhibit because if you read this bottom left comment,
which part
on the picture?
Oh,
when they're in the hallway, it says, however, other witnesses state that the paperwork was given to him in line by them, not the judge.
No, these posts are actively working against him. So I don't know why he included these at all.
So I actually have as a, what do you call it? A journalistic source, the person who claims to have given this pretrial statement. It's just a pretrial statement, which is publicly available documentation. From both sides, and I think this was Woodnick's because it has the interesting things about the tight JJ email or whatever in it, and that's why the person gave them the copy to read. It wasn't the judge; it was just another participant watching the case, and that's what my source has told me, and I believe them. I've talked to them in person. I've verified their identity, all that jazz.
I mean, he and Laura both, they're always like insisting that certain people did XYZ behind anonymous accounts. And even when people come forward and they're like, yeah, that's not what happened. It was me, or that was not that person. It's like they won't believe it. And they keep using it in these legal filings. And I'm like, you're ruining your credibility with this. Also, like you just pointed out, like these Instagram posts obviously say that what he's claiming happened in this paragraph did not happen. So this is not supportive of his claims right here. He's literally working against himself by including these posts.
There's alternative allegations.
Yeah. Oh my
Luckily,
God.
I think if the judge does what Omar's explaining, they won't even read this until they rule on the first motion. And then
Right.
this will just be a renewed motion. But there's already precedent for it being denied.
It's pretty irrelevant, yeah.
Oh man, I just think it's such a like waste of time for him to like pick on social media accounts like this and try to be like, these people, look at these awful, horrible people and what they're doing, and the judge is wrong for this, or whoever's wrong with that. I'm like, these social media accounts, like, they're just exercising their freedom of speech to comment on your public proceedings. It has nothing to do with your court cases. Can you please just shut the fuck up? It's so obnoxious.
You know what's interesting about David? Like, he's very clearly not. He's not a stupid man. I mean, he's
I think he's
not.
pretty stupid, and that's just
I
my
mean,
opinion. But
It's not that he's not stupid. It's just that he's intellectually capable. Let's just say that.
sure,
But like the further that he gets in the weeds with this case, like the more ridiculous like his arguments become. Like just this whole premise that Judge Mata's dad was there and therefore her performance as a judge was somehow compromised. And he wrote this whole blog post about how his mom was there, like watching him in Hey Rob's case. And like it caused him to really focus and to focus on every single word and like do his very best. And so like it was a positive thing. And I'm thinking at the end of it, like he's like, oh, so I can see I was wrong in that. And then he doubles down, like, see, that's especially why your parents can never be there, because it's going to somehow affect, I guess, positively or negatively your performance as a litigant. It's just I don't understand the premise. I haven't for a long time understood his legal arguments. I don't understand this legal argument. Even the whole thing about he's telling the truth and that somehow absolves his conduct, which the state bar's complaints against him are largely based on his conduct. It's not a defamation case. It's not a First Amendment case that he was trying to turn it into. And so he's alone and he's backed into a corner and he's in his own head. And in the space of his own head and all of its intellectual capabilities, he has cornered himself and he's coming out with all of this ridiculousness that is causing people that are in this profession to just take a step back and be like, God, if that ever becomes me, you know what? Just it's time to get out. It's time to leave. It's time to retire. It's time to pack up and go.
Or just take a break. Just
To be fair to his argument, I think his argument is that his mom was there, so it put pressure on him, but he's a lawyer making arguments. He's not a decision maker, whereas a judge is a decision maker. So if having a parent is going to swing you in one biased direction or another, you are the decision maker. So it's a different job. That's his argument. I don't buy that argument. I think parents of judges should be able to attend court cases because they're members of the public if they want to.
mm-hmm.
But I think that is his argument.
Oh, I understood the argument. It was stupid.
But
I mean,
even-
yeah, I don't buy it, but I'm just saying it's not that he and the judge have the same job. They don't, which I agree with.
Even as the argument goes, though, if I'm a judge sitting up there on the bench, I'm like, as you say, I'm not making arguments, and I can take as much time as I want to decide, unencumbered by anyone that I know or care about being involved. So it's a completely different process. When you're arguing, that's it. That's your one bite at the apple.
Mm-hmm.
It's a lot more pressure than a judge, to the extent that, if the judge is ruling on objections and stuff like that. But, all of her rulings on objections were fair.
Yeah, the judge did not rule from the bench. The judge took the hearing under advisement and could have taken as much time as they needed to do their ruling.
So
Does he live in Hawaii?
Who?
Mr. Howe. Does he live in Hawaii? Because he's talking a lot about Hawaii cases.
He's citing a case in Hawaii that he likes.
Oh, no, yeah, he's saying that Hawaii applies the rule differently, and this is how we should apply it.
Okay. Is that...
That's when he was like, I guess we're going to make some new law. It's like, David, you are making all sorts of new law. It's just not the ones you want.
What? Okay, all right. Because doesn't he like regularly criticizes people for using out-of-state or unpublished cases, and now he's using a case from Hawaii? I don't... All right.
Well, I once criticized him of using federal cases in a state case, and he got really butthurt about that. And so ever since
I
that,
didn't like that. No.
How'd that go?
well, and when is how you thought it would go.
The absurd thing is, in some video he made, he said, "Oh, Omar's like the dumbest person I know," and I'm like, if he's the dumbest person you know, how did he accurately predict the outcome of the paternity case? How did he accurately predict the outcome of the appeal with the proper citation to Rule 25? By the way, and he kicked your ass in California? So, like, what? How is that the dumbest person you know?
I guess it's all a matter of perspective, you know.
Yeah.
So take it with a grain of salt.
And this might be the first time where, I mean, I think it is the first time where he hasn't been able to paper a file to the point of things getting dismissed. Like he is, I would say, first and foremost, a dismissal lawyer, meaning like if he gets the case dismissed, that's a win for him, which it is certainly a win. But it's a different game if your goal is, how do I get this case dismissed?
Okay, we have this here where he says any judicial privilege that might apply has been waived. I don't.
Let's read this.
Yeah. Okay. Unlike her father. What's that? Yeah. Go ahead. Go ahead.
Unlike her father, Judge Mata's objection focuses primarily on privilege, arguing judges cannot be asked to explain the basis for their decisions. To be clear, respondent generally agrees judicial thought privilege limits the ability of disappointed litigants to demand a judge answer questions about their thinking and analysis. This argument has no application here for two reasons. One, respondent's subpoena seeks documents that have nothing whatsoever to do with Judge Mata's legal thinking and analysis in Owens. And two, even if respondent did seek that information, Judge Mata has waived any privilege that would otherwise apply. Well, okay, let's keep going. None of this makes sense. Arizona law establishes many privileges. All privileges have one thing in common. They are all waivable under appropriate circumstances, unless a third party can claim the privilege on your behalf, in which case they're not. One of the clearest forms of waiver is a rule which holds as a matter of basic fairness. Privilege cannot be used as both a sword and a shield. That is, a party cannot seek selective invocation of the privilege, disclose documents or testimony favorable to that party while failing to disclose cogent material unfavorable to that party. Privilege cannot be used, that is, a party cannot, by selective invocation of the privilege, David. That means they can't say, well, I thought about this, but I'm not going to tell you what I thought about the other thing. That's selective invocation, you fucking moron. Implied waiver prevents a party from asserting a particular factual position and then invoking the privilege not only to support that position, but also to prevent the opposing party from impeaching or otherwise challenging it. Oh, I'm gonna have to read that again. Implied waiver prevents a party from asserting a particular factual position, so saying something that happened, and then invoking the privilege, something happened, and then invoking the privilege not only to support that position, but also to prevent the opposing party from impeaching the other or otherwise challenging it. Well, yeah, no shit.
Hey, could we pause?
Yeah.
So just some observations. Number one, this was 100% written by AI. You could just, the syntax is like, this is the way that you waive it without giving like a cognizable example about why it's waived in this case. Like this is either a 1L writing sample of like something they wrote in class, or AI wrote it and now he's going to somehow try to weave this into Judge Mata. But the other thing is, since when is Judge Mata on trial? Like when is her legal decision on trial? Like this is all about his conduct, and this is going to stuff that he's trying to subpoena. And he just says, like he says, I generally agree that we're not allowed to get into the judge's thought processes, except in this specific situation. We don't have a specific situation.
His argument is that they're using privilege as a sword and a shield. But given that he stipulated to so many of the actions that the bar charged him with, I don't agree that they're using privilege as a sword.
No, you're right.
I do
That's not
agree.
actually 100% right.
I do agree with you that it seems AI written, because who writes a filing and starts talking about priests and doctors and their privilege? Like, what is this, third grade? Why are
Yeah,
we
well,
including something about doctor-patient privilege here? Like, come
David's style
on.
was a lot different. And,
It's a
and the other thing
kindergarten.
is, yeah, it just how is she using? I don't understand what he's claiming that she is waived here. I guess I'm just lost. I need to read further.
No,
I need
no,
more.
he's asserting that they are using the privilege that Judge Mata has, or the deciding body has decided on, to just say, look, there's privileged thought process for a judicial thing in the court case. And he's saying it's a sword and a shield. If we give him the shield, I still don't see the sword. His argument seems to be that because I can't defend myself, you're stabbing me. And I'm like, I don't think so. You did this. You stabbed yourself, sir.
These paragraphs kind of, I guess, line it out a little. Like, it doesn't make much sense to me, but it lines it out a little bit better. It says, clearly the state bar had a Rule 11 obligation to investigate the claims before it filed this proceeding. That means the state bar must have interviewed Judge Mata about these issues, and she must have answered questions which the bar believes are sufficient to support discipline. It says if the bar did not interview Judge Mata, it violated Rule 11 by filing serious charges without investigation. In that posture, by agreeing to answer the bar's questions, Judge Mata waived any privilege that might otherwise have applied here, just as a client waives privilege by disclosing otherwise confidential information to a third party. As a matter of basic fairness, it would be grossly unfair to allow the bar to interview Judge Mata, obtain testimony from her favorable to their position, and while simultaneously allowing her to invoke privilege so she can withhold information that may be unfavorable to their position.
That's the
I guess my point is,
argument.
I know, but I guess my point is, I believe that isn't Judge Mata's argument in her motion to quash that virtually all of the stuff that he's asking for is basically irrelevant to the complaint.
Right.
And so we don't even have to get to the point where, we don't have to get to the part where it's privilege. It's just not relevant. So we never reach that argument, that portion of the argument, I guess would be my point.
But he just doesn't believe them.
Well,
so he has an argument from incredulity. He just doesn't believe that there's no evidence that exonerates him.
And how does he know that Judge Mata didn't go in and say, I have privilege over my judicial thought process? I'm not going to.
That was my other thought. Yeah.
Right. Well, he doesn't know that because he keeps complaining that Jim Lee won't tell him what she said. So he's basically making these arguments with nothing to really back it up.
Well, so if they're not using any of Mata's answers in their complaint, and they're largely saying that because of his admissions based on the pleadings, they don't have to get into any of that stuff, then there's really no reason for him to get into any of Mata's answers in the first place. And Patrick is right. She might have just walked in there and said, look, all this stuff is privileged. I don't have to disclose any of this to you. And like the other stuff might have been just like a basic top level stuff.
Well, if they asked her like the question that she basically answered when she wrote the motion to quash, did you rely on social media posts to make your ruling? And she said no. And she's also said in her motion to quash his subpoena that there's nothing responsive to that question because she did not look at social media posts. It's like,
I don't think the bar had to ask her anything. She filed a bar complaint that effectively said, look at what this guy is doing online. Look at what he did in this case that's on the case record. All the bar has to do is go get the case record and go look at what he's done online, and they can decide if they want to sanction him for behavior.
But he's talking
he
about
is not the sword. All they have to do is look at what he did, which is why I said earlier, he stabbed himself. She is not the sword.
Mm-hmm. Yeah.
I agree, but it still doesn't make it not like he's still allowed to have discovery in his case. And the discovery would be the complaint that he filed against Judge Mata that he believes was investigated and has this information that he wants about her judicial thought process. But I agree, she could have easily just gone in there and said, hey, this is protected by privilege. And even if it wasn't, the facts of the case clearly support my overall rationale.
But is his complaint material to the bar sanctioning him? You're saying he filed a complaint against the judge?
Yeah, the fruits of the complaint, so the investigative file that is attached to the complaint, is what he's saying is relevant to his case.
How is it? Where is that connected?
Well, that's already been denied. That motion to get the CJC records has been denied.
No. What I'm saying is, in the complaint material we went through, it took like 3 days that the bar filed against him. Where is the output of his complaint as an input to that? Where is that connective tissue? I've never seen it.
Oh, that's a great point. It would be more of a mitigating factor than a legal defense.
Exactly.
Yes. So it can go to mitigation, but I guess where it would be him posting that Judge Mata is like, beware of Judge Mata. A defense to that statement would be truth, I suppose.
Yeah.
So that's how I would connect it.
Okay. But the bar charges are not saying he's lying. They are just saying they don't like his conduct.
That's a great point too. I can't argue with that one. Yeah.
Yeah.
Okay, hang on. Let's move on to the last. We got a few pages here left. I skimmed over some stuff because it's like we've like gone over this over and over again.
Sign me up for law school, Lauren. I'm ready to go.
Oh my goodness. It says respondent accused Judge Mata's specific discrete acts of judicial misconduct, which involve her speaking to her father about a high-profile case, printing documents for him from the docket, which has already been disproven. Even in the evidence that he cites here, it's been disproven. And making a factual finding that was based on extrajudicial information, not evidence admitted at trial. Although the state bar disingenuously suggests these are objectively false statements, they are objectively false. Even the stuff that he puts in this filing shows they're objectively false statements, implying they could be proven true/false by referring to some objective evidence other than Judge Mata's testimony. Okay. The truth is this: no one other than Judge Mata and her father are in a position to say whether these claims are true or false. Okay. In that unique posture, respondent is clearly entitled to interview both Judge Mata and her father and to obtain any relevant non-privileged documents which bear on the truth. Well, the thing is, he's asking for privileged information, though. Yes, in regards to like her judicial thought process.
Yep.
As far as the father goes, like there's probably just nothing responsive to his fucking questions. As far as her father goes, like, oh, I got a copy of a document in line to watch this like a public proceeding. You think what is the fucking response to that, really?
I think he's conflating this idea that when someone says, hey, look, Jingras, you made a claim or you're speculating that maybe something sketchy happened, but you haven't given us the evidence, so we cannot confirm your claim. He seems to be conflating that with a binary situation in which either people think the claim is true or false. This is, again, even if there's a jar with marbles, there's either an even or odd number of marbles in the jar. If we don't know how many marbles are in the jar, the answer is I don't know. If Patrick tells me there's an even number and I say, how do you know that? And he says, I'm not going to tell you. I can say, I don't believe you. That does not mean my position is that it's an odd number of marbles. It just means you have not proven the case to me sufficiently yet. And I think that is the argument the bar is making it. And he's conflating it into a false dichotomy here.
I totally agree. I can't get what you said out of my head about he's not charged with saying that what she said was that she lied. He's charged with his conduct towards her, and that makes her judicial thought process irrelevant.
Right.
Correct.
We lost Omar, but he's back now.
He's back now.
I was trying to respond to comments, and I'm just not going to do anything anymore.
Okay, so he's talking about the meet and confer process. The bar suggested this matter is similar to a recent California case in Re Olin. In that case, the California bar found 5 out of 8 charges against the lawyer involved speech protected by the First Amendment, resulting in those charges being dismissed. Okay, but you haven't really shown that the speech that you are being potentially disciplined for was outside of the bounds of the disciplinary body that's overseeing you. Is my kind of thing. So.
And also, he's not talking about what the speech was or the context of it.
Right.
It's not a speech thing, though. It's a conduct thing. Like, that's
He's
the North
all
Star for
over
this case. It's he wants to make this a First Amendment case. This is not civil litigation, First Amendment stuff. This is he conducted himself in an unsavory way that has got him facing discipline. The truth of the matter is not a defense for his conduct.
Yeah. I don't. It seems like he's arguing a whole bunch of stuff here that's not relevant to a motion to compel.
Go figure.
Yeah, that's what I'm saying. Like, this is. I mean, I guess the whole point is, well, it should have been broken out better. But one, if there is a privilege, it's been waived. Two, I have a First Amendment right to see it for some reason.
Mm-hmm.
And now I don't know. We're still going.
Well, I think he's making a due process argument that he has a right to see it, or at least review the answers. But I mean, attorney work product.
Oh yeah, that reminds me. He was saying, like, if I get disbarred in Arizona, I won't get disbarred in California, because California won't disbar you if you have lost your license without due process. And I'm like, David, you're getting all the fucking process, bro.
Right. Okay, so here, just to go back, this is kind of bizarre. The court in Olin found the following statement by a lawyer was not protected speech. It says, if I ever won the lottery, I would pay someone to kill Commissioner Feezy's minor child. Okay. Given that respondent lawyer threatened to kill a judicial officer's minor child, it's hardly surprising the commissioner testified about this threat during the discipline proceeding. During his disciplinary trial, Commissioner Feezy testified that she was frightened when seeing him and left the courtroom to lock herself in her chambers. What does that have to do with judicial thought process?
That's
in
a
the case.
fact. It's a fact. It's a fact. It's not the judicial thought process.
I'm so confused. I'm like, what does this have to do with Judge Mata's thought process behind her ruling? Did he threaten to kill her child? What is happening here?
I mean, no one is saying she can't be called as a witness. As a matter of fact, she is being called as a witness.
If the California Bar was able to call a judicial officer as a witness during the disciplinary proceeding in Olin, where a minor child was threatened, the life of a minor child was threatened, mind you, surely the same is true here. But at the same time, the bar cannot solicit allegedly favorable testimony from Judge Mata while simultaneously prohibiting David from pursuing discovery, which is intended to refute that testimony. I mean, he doesn't even know what she's going to say yet. He's said over and over again that Jim Lee won't tell him. So,
well, also, it's allegedly favorable testimony. Where is the testimony? Like, well, you can't cross-examine testimony that doesn't exist yet.
And the judge the state bar on direct examination of Mata is not going to ask her a privilege question. Why would you step on a rake like that and waive the privilege? Right. They're going to ask her
because he would do it. Maybe he thinks that because he would do it, maybe they would do it.
I'm assuming that he has Judge Mata's bar complaint, correct?
Yeah,
I think so.
And so, therefore, if she were to testify as a witness, then largely what she's going to testify about is in that letter. And so, there's no element of surprise here. And anything else that might come up, they could argue attorney work products. They could argue privilege. They could argue a lot of things. They could just simply say that they didn't really ask her about anything other that's in the complaint. But maybe part of their strategy is Mata could potentially be used to impeach certain aspects of David's testimony. I don't know. But if he has her bar complaint, then he's not going to be shocked by whatever it is that he has to say. And the fact that he wants to litigate like certain aspects about her thought process or whatever, I'm failing to see how that's relevant to his conduct towards her in general.
If he filed a complaint against her and there was a resulting investigation, I think that's what he's more interested in, not the other way around.
I know,
but maybe they only asked her about what she said in her complaint. So why is it relevant what the investigation was in his complaint? So like if she said, yes, he wrote this extremely disrespectful statement about me to the court, look at me, daddy, or whatever, and then wrote to the appeals court basically that the Judge Mata, was, inefficient and gross and incompetent because of a reality TV star being the subject of her case. And he did suggest that she ruled against them because Clayton was a reality TV star in his pleadings. Like that is something that you can testify to without ever having to reveal anything about her judicial thought process. So,
I
like,
don't even think you need her
True.
testimony to prove all those things. I'm pretty
Right.
sure that
just look at
David's
the
already
pleadings.
admitted those things.
That's exactly what I was saying before. All you need is her written complaint, and then you investigate his actions, which are in the court record or on the internet. And you, as an employer, the state bar, have grounds to sanction your employee. You're done.
And there's nothing that he's going to cross-examine her that's going to mitigate those truths, those facts.
Correct.
In his conduct, which is the basis of Mata's complaint, which is part of the state's case against Jingras in the upcoming trial. And so I don't understand what he's trying to compel here.
He's
That's gonna be
he's
relevant.
imagining alleged testimony that he cannot cross-examine. That's all he's got is imaginary.
If you study his blogs, if you read his blogs, he has no interest in cross-examining her on all of these things. He just wanted to threaten her with he's gonna subpoena her and ask for all of this stuff, and he could go into all of these different areas that are not particularly relevant. That's what he's ranting on about his blogs. It wasn't about the merit of what he was going to recover. He said that, look, now that I have this subpoena power, he was going to weaponize it against Judge Mata and all the people that he didn't like. Woodnick was in there, all these other people that were involved in the bar complaints and the fact patterns. And so he's already previewed that part of his process, his discovery process, was going to be the weaponization of these subpoenas. And so now, when they're moving to quash them, he's trying to, I guess, make an argument. He has to make the argument. Then what is specifically relevant about what you're asking for? And I can't make a good argument for him in that regard. I guess that's my confusion with him.
But to what end are all these threats? Is he just trying to make so much bluster and threatening noise that the governing body is just like, this is just too much work. We're just going to leave it alone.
100%. That's one of his strategies.
We're just going to dip out as fast as we can.
Well, we've
And it
seen that
minimizes the damage.
since 2024, we've seen him weaponize litigation strategy that way, just muddying the waters as much as he can. I have subpoena power. I can write these things. I could become an intervener and muddy the waters. I can do whatever. I can use whatever tool is available to me as a litigant to make everybody's life a living hell. If you want to fight, then you're going to get one. That's kind of the way that he litigates. And I don't see him taking any different strategy here. That's basically what he's doing. And now they're not letting him do it. And he's lashing out, I guess, in these pleadings. I still don't get how this is a motion to compel before we haven't had a ruling on the motion to quash. Let's revisit that question. I'm just saying.
That is kind of odd.
I'm confused by that still, but okay, we're gonna get to the end here because I got to go to bed soon. But it says all of her remaining objections are groundless. For instance, she suggests Respondent Jingras has offered no legal citation to warrant the release of information from a non-party. That statement is simply false. Respondent informed Judge Mata's counsel that Civil Procedure Rule 45 expressly authorizes the issuance of subpoenas to non-party witnesses. Well, whether or not he's authorized to subpoena her is not really the issue, no? But he doesn't have the authorization to get the information that he's asking for. So he can issue the subpoena, but she's not, maybe based on that rule, required to comply if the judge or the orders that she doesn't have to do so. But he's like asking for like shit related to the robing room post. And I'm like, what do you mean that's groundless? You need to explain why you have the right to get shit from the robing room related posts, like her rulings or anything related to something to do with a snake. Any cases she had to do with a snake, which is random as fuck from like whatever time period. Like, I think that's not groundless to object to that.
Yeah, I think he's just fishing because he wants to like,
Right.
oh, look, see, here's a bunch of evidence that proves she's just going back there and Googling random stuff to make rulings.
Right.
Like, it's just speculation and I don't know.
So he's saying she claims respondent engaged in a fishing expedition and has made no credible offer of proof. But then he says that argument ignores the multiple video recorded witness statements cited above and the lengthy affidavit in which he discussed those exact issues. So those are basically his statements, which are the same thing we're reading over and over again here. And also the cited evidence above, which we saw that actually refutes his statements. So
And that paragraph is also legally incorrect about the Civil Rule of Procedure 45. The way Arizona's attorney discipline court cases work is the attorney discipline has its own rules of civil procedure, and there's one rule that in those special rules that says, okay, these rules from the rules of civil procedure, those are now incorporated into the rules for attorney discipline procedure. Rule 45 is not incorporated into the rules of attorney discipline procedure.
Okay. Well,
oh dear,
that's not important.
That's really lazy.
Oh boy.
Also, his evidence is not evidence of any wrongdoing. Okay, like if the judge's dad actually went to the overflow room, so what? It's not wrongdoing. I don't
His
even
evidence
think...
is like this Instagram account that I called liars is saying this. So that's my evidence.
I mean, it doesn't make sense. I mean, he's asserting that the judge had some papers, but he hasn't proven where the papers are from. He's just speculating.
But you can't
It
both say
doesn't-
that everything that comes from a specific source is both definitely untrue and also certainly true in your case. It's just
like a lot of things could be true, but we can't spend our lives like just assuming that all the worst case of every single possibility is true. Like at some point we have to actually go do the work. We have to say, I don't know. Let's go do more evidence and see if we can find out.
Well, luckily, when we have these pleadings, you have David, and he's ruminating in his own filth, coming up with these tangential arguments. But then they get in front of the fact finder, the person that's going to make the decision within 30 seconds. They'll be like, "No, bullshit."
yeah.
Motion to quash granted.
That's
Yeah,
By the way,
yeah, and we've seen it over and over again. So to me, it blows my mind that so many of these things can happen, and the light bulb doesn't come on, right? Like, clearly you're going down the wrong path here.
yeah, Patrick, what is the meaning behind that word, that name, your screen name, lolcow?
Oh, lolcow. It's what David is turning into. A lolcow, the original lolcow was this guy Chris Chan, and basically it typically indicates like some type of online personality that is very easy to troll. And so a lolcow is someone that, you know, an online person who other people who are online can basically get them to do things in the real world. You have to go down the Chris Chan rabbit hole on your own. There's Cyrex, there's Rest in Peace, King Cobra JFC. There's a lot of them.
Hey, you want to hear something funny? I have you saved in my phone as Steven, attorney.
Perfect.
And I've been calling you Steven for all this time.
You texted me once. You were like, "Sorry about that." I was like, "No one can pronounce my name anyway. It's fine."
Well,
I always thought Omar had found some new lawyer who wanted to commentate on the case, and then you showed up, and I'm like, "Wait, that's not a new person."
I was like, "Wait, let me share my screen real quick." Are we wrapping up?
We are, but I can pull your stuff up anyways. Let me just do this real quick. Joel's and Emma chilling. Thank you for the $5. DG reminds me of a 3-year-old who got into the cheese puffs, and when you ask if he ate any, they say no with cheese on their mouth and fingers.
Oh no!
And Cynic and Chief, thank you for the $2. Isn't this filing project Hail Mary for David Gingras? Yeah.
That
sounds like all
dog anytime I leave Chinese.
Yeah. What do you want me to show here? If you share your screen, I can put it up.
while he's doing that, I have a funny vacation story.
You're good.
So I'm in Cancun. I'm with the girls, right? And Olivia, like we're walking to like some different pool, and I have her by the hand, and we're like walking. She's talking at me. She's like, "Dad, do you remember that time? And you told me not to do that, and then I did it anyway." And I couldn't understand what she was saying, and she was getting frustrated because I was not understanding her. And we walked by like the biggest group of people, and she's saying, "You told me not to go in the pool, and I did it anyway." And then she's like, "I pissed in it." And I'm like, what the hell? She was trying to tell me I told her not to pee in the water, and like 2 years later, it's like, well, I peed in it anyway. But the way that it came out was just like at the most perfect time in front of this huge group of people.
Did she say piss or pee?
She said, "No, I pissed in it."
Oh my god, that's amazing.
Emphatically.
I love that.
Talk about relinquishing your information privilege.
Yeah, that's a waiver of a pee privilege right there.
That's a big waiver.
Those
Yeah.
privileges are waived. How about that?
So as I was saying, David cites Rule 45 as a way to clap back at the AG's office, who literally handed him his lunch. And Rule 48 of the Rules of Supreme Court of Arizona for attorney discipline cases, the rules of construction, in Rule 48B, it says rules of civil procedure. Only the following rules of civil procedure are applicable to attorney discipline proceedings. Let's see. Is there 40, 45, 43, 44, 56, 60? I'm not even licensed in Arizona, David. Get your shit together.
Oh dear. This is
Patrick, David Gingras has been a First Amendment attorney for 25 years. Who are you to question him and his expertise?
I looked up locale lawyer on Westlaw, and I haven't seen any published decisions, so he must be a piece of shit.
Oh no.
David, buddy, you can't be doing that.
Oh man.
It reminds me of the appeal when he was, what was it? Rule 25C or something. And it was like, well, this is the one that actually applies. And he just ignored it. Right.
Yeah. I remember that. Yeah. I mean, I hate wasting my time and energy on him because he's so wrong and just such a bad human. But at the same time, it's like the record needs to be correct. Like, I can't have someone out there making a mockery of my profession.
Well, there's plenty of lawyers out there that do that.
Yeah, we can do that all by ourselves.
I mean, honestly,
right
it really is only that he brought his shit to the internet. Like, he could have continued on doing this forever, and we would have never known any better.
They don't all also threaten to sue your friends. So it's like, you know what I mean?
Personal grievances, that's for sure.
Yeah, right. Or like falsely accuse your friends of rape. It's kind of like there's a personal element to this for pretty much everybody.
Yeah.
Well, hey, Christina99 wants to know if pissing in the pool is a regular thing from professional swimmers, Lauren.
Yes, it is.
What say you on that issue? Okay.
It is absolutely a regular thing. I know that people tell their children not to do it, and people tell your kids that adults don't do that. They do. We all did it. Sorry. I don't know what to tell you. Hopefully you guys never swam in the same pool that I did, because I've eaten it, and so did everybody I know. So
like when you're practicing or when you're competing or both? Or like what? Now, when you're competing, I can understand. Like if you have a big race and you just gotta.
And not during the race. You usually let that out beforehand. But if you're in the middle of a practice and you want to like go to the bathroom and it's just a pee, and your coach is going to scream your head off if you ask to take a break and go to the bathroom, you're just going to pee in the pool.
Why are they yelling at you like that? That's weird.
I can tell you've never been around a swim practice in college, but you know.
All I can think of is the Billy Madison quote: "Pee in your pants, it's cool. I'm Miles Davis."
Aren't they doing a sequel to that movie?
I think they did it.
Why not? They did Happy Gilmore.
I know they did a sequel to Happy Gilmore, but I think they're also doing a Billy Madison sequel.
Veronica Vaughn, my first crush.
All right, guys, I gotta get to bed because I have to. Lauren can pee on me respectfully. Well, respectfully, I don't have to go to the bathroom at the moment, but
Whoa.
yeah, okay. You wait for me in the pool. Like,
Well, she's
Lauren
already
has
peed.
unlocked a new revenue stream.
She's already peed in the
Freaking
pool
extreme.
disrespectfully. so-
Literally. I saw on Mugshot Shorties today a woman who was arrested for like public urination in like 2 different
Oh,
Airbnbs.
did you see that?
Yeah.
That's crazy.
oh well, you're not gonna
I
catch
found the
me like
video.
going to the bathroom in a park or something. Like you don't whip your suit down to pee in the pool. You just do it. Like
I wanna know how they caught her. Like, what are
She
you
posts them to
doing?
OnlyFans. Yeah. What
Yeah,
are you
but like, what's the guy's googling what to find that lady that did that, and then they're like, "Oh wait, that's my lamp." What's going
this is not my area of expertise.
That's my pool table.
What the?
What's happening? Oh, she's peeing. Oh, she's peeing a lot.
I
Oh,
better go check that toaster out. What's happening there?
Oh,
I did
my-
once swim in the same swimming pool as Lauren, and I don't think that she peed in the swimming pool.
No,
You
no,
weren't in there for very long.
no, not that time. I didn't. No.
Well, I lost anyway, so
I think you should subpoena her to find out.
yeah, but just
Um,
don't pee her off.
Oh my god, you guys are so lame. I can't do this. All right, I have to go because I have to go to bed. I have the dentist appointment in like 8 hours.
Urine not impressed. That was not very
Wow.
good. Okay, that was not good.
That was the worst one. All
I
right.
hate that. I hate that I ended it like that. I'm sorry.
That was
These-
worse than the one that said they would pee on me.
These jokes are in the toilet.
All right, bye guys. In the chat, I'm sending you over to MG Law. Please tell him I said hello, and I'll talk to you later. All right, I'm ending the stream.
That's
all right, bye,
ending
folks.
the stream.